Then my lord, item 1, my lord, sir, directed for compliance of the order, or else a notice was issued, police notice. In the meantime, we have complied the said order and passed the same, and it has been duly communicated to the party concerned.
They have rejected your lordship dispute.
Merit of the case.
With a liberated copy.
I have filed it in e-file, also given the hard copy.
That is not there, sir. You have the file.
E-file is not there.
No, e-file is there, some.
This file is
fine.
This case arises on the alleged violation, alleged non-compliance of the order dated 11/9/2025 entered in the writ petition number WPC number 945 of 2025. First, this court by the order dated 11/9/2025 at the operative portion has said as under, only for the operative portion. Next person. After police notice, after service of police notice, the opponents having entered appearance to the learned AGA submit that the order has been complied with by passing an endorsement dated 28/11/2025. A copy whereof is already served on the complainant. First off. Next paragraph. One more sentence. Therefore, proceedings be dropped. There is force in this submission. Next paragraph. In the above circumstances, the proceedings in contact number 52443 of 2025 are liable to be dropped, and accordingly they are, reserving liberty to the petitioner to work out his grievance against the subject order, else in accordance with law. First off, in that connection, all contentions are kept open. Yes. Next.
Item 2.
May it please, my lord.
Yes.
My lord, a government housing scheme was floated in 1990, wherein a plot was allotted to opposite part number 6. But after 4 days, it was allotted on 29th March 1990.
29/3/1990.
On the annexure 1.
To whom it was allotted?
Allotted to opposite part number 6.
OP6.
My lord, by the Orissa State Housing Board. And 4 days after the allotment, what happened when due to the financial problem and illness, the opposite part number 6 left Odisha, gone to his home state of Punjab by executing a power of attorney and an agreement in favor of father of opposite part number 7. And the condition was, after clearance of all installments, sale deed will be executed. And in the meantime, all installments were paid, and the father of the person who obtained the power of attorney and agreement, he has also died. His son, he has transferred the
entire money.
money. His son,
Take notice.
my lord, I have last representation is annexure 11. If my lord direct, it has board can consider representation and do the matter. Because it has already processed. I've heard that already they have gone to the place and verified. So 2 months back. So if my lord gives them 1-2 months, then matter can be, because for 30 years.
That's all right. Let notice go. After service of notice, this order I will.
My lord, initially, I want that if my lord will consider, direct them to consider my representation under annexure 11,
I would have
it
considered.
can be considered.
But decades have lapsed now.
My lord,
Therefore, let notice go.
all right, my lord.
We'll have their say.
Well.
Then we can do
Well.
that all. Issue emergent notice.
Here, my lord, state is for 1 and 4.
Mr. Mohanty Learned
The contesting party is 2, 3.
1 and 4. Emergent notice to the rest. Returnable.
By speed
for-
post.
Yes, okay. Next.
Item 3.
Requisites my lord by debt proof.
Three working.
My lord.
But matter is relating to RSCP of primary school teacher, my lord, and covered by Saraswati Bhai, my lord.
Have you served a copy on the other side? You should be kind to the court, kind to the lawyers,
My lord.
government lawyers also.
My lord. This is my lord's judgment, keeping in view that Hon'Ble Appeals
That's
Court.
can do that.
Item 4.
Please, Your Lordship. There is a matter relating to grants of increment, Lordship, retrospectively with effect from 1/6/1994. Similar matter, my lords have disposed of. I have corrected.
All three same.
Yes, Your Lord.
Yes, the factors.
Yes.
The representation is annexure 8, Lord.
In all annexure,
Annex 8.
huh?
Yes.
Same date.
No, Your Lordship.
Date is different.
Huh? Look into, they have not written the dates there. Change the dates. Okay.
All three are same, Your Lord. Connected. Grateful, Lordship.
Item 5.
Yes, sister.
That is madam, can you see that? Page 13,
Drag the light.
page 13, madam. By directing the opposite party forwarded the service book and the grade calculation of grade pay, my lord. That is third RSP, my lord. That is wrongly fixed, my third RSP. I am challenging second term litigation. I am challenging annexure,
Ashok Kumar Mohapatra.
my
They
lord.
are relying upon Ashok Kumar Mahapatra.
That is put in challenge? No. Where is your representation?
Representation only the second term litigation, my lord. Representation already rejected, my lord. That is annexure 11. I am challenging annexure 11.
Requesting notes of the. Oh, please. Matter lies in a narrow compass, post it. And it's a second round litigation and therefore post it in the third will cost another.
Item 6.
Yeah.
Yes, my lord, this is a matter, my lord. The present petition is a young aspirant for different examinations, my lord. My lord, as per the prevailing custom in the Western Orissa, my lord.
Title in the BSc certificate.
Yes, my lord. To amend the title, my lord. The title is Baria, he want to change it to Rajhans, my lord. The Baria belongs to the SC/ST community and Rajhans is OBC. By birth, he is a OBC, my lord. But by virtue, my lord, he was sold out by his parents as a symbolic manner to a lower caste person's, my lord. So that title has been changed, my lord. So now
What are these castes? Lord Krishna says in Bhagavad Gita, Chatur Varna Maya Srishti Guna Karma Vibhagashaha. He does not speak of caste at all.
my lord.
Where were the castes? Ramayana is given by a scheduled tribe man. Valmiki. Bhagavad Gita by OBC.
My lord.
And many Vedas are given by people belonging to downtrodden classes.
My lord. But when presently he is
Gayatri Mantra, which Brahmins chant,
Mal.
it is given by Kaushika, Kshatriya.
my lord.
What is there?
But presently, my lord, when he is applying for different examinations, my lord, this Baria caste belongs to SC/ST, my lord. But he belongs to OBC, my lord. So that is the problem, my lord. He may be executed as a for fraud to the certificates, my lord. So by mistakenly it is mentioned as Baria, my lord.
Consider representation.
My lord, that is Board of Secondary Education is the appropriate authority, my lord. We don't have any role to play there.
Representation to the
So representation is there, my lord. Representation
Really how made?
to the that is the
That is Annexure 3 at page 9.
Board of Secondary Education.
Mr. Rao appears.
Mr. Rao usually appears.
You bring, I will issue notice to him.
Mal.
We'll call this matter next week and then we do.
My
Right?
my.
We should forget all this in the new constitutional order.
But the problem is
not there.
But the problem is by the reservation in the different examinations.
But it does not depend upon the title, your name.
Yes, my lord, because on the schedules, my lord, it shows, my lord, this titles is coming from this issue.
Just notice.
OP number 2.
Mr. Mohanty for OP number 1. Emergency notice to 2. Mr. Rao Lavnit, the senior panel counsel, is requested for such notice for OP number 2. Petitioner to serve a copy of the petition along with all the documents on Mr. Rao. First off, if that is done, post this matter before.
The date may be given.
Next.
Item 7.
Against the illegal action of the managing committee preventing him to discharge his duty, petitioner file an appeal before the appellate authority director. Now director has rejected, which is under challenge, my lord.
You have filed appeal.
Appeal that has been rejected.
What was that appeal?
Appeal, my lord, I was prevented to discharge my duty as per the government circular. If an
Appeal under 24B.
no, my appeal before the director because the institution status is a private school.
What he says?
He says that since your appointment, at the time of appointment, you are not a BED trained candidate, your appointment was rightly terminated, even though no show cause was submitted by the managing committee. He admits that managing committee could not able to produce any show cause notice, even if the termination order was not produced.
Issue emergent notice. AGA requested the notice for 182.
3-4.
Just notice to 485.
Correct.
1, 2, 3 here.
I is a private party.
Private.
Distribution.
Yes.
Item 8.
No, please, my lord. And the petitioner is working as a peon in a headed institution, my lord. My lord, she is eligible to get third MSCP, my lord, which has been held up due to pendency of a criminal case, my lord.
Where is that?
My lord,
What is the criminal case?
criminal case is pending. Trial has not been commenced, my lord, yet.
What is the offense?
Offense is 420, my lord.
20.
Yes, my lord.
Brother, can you, on the ground of pendency of a criminal case, can you deny the benefit? We have already taken that view, na? Which is that judgment.
That judgment was, I'll give that judgment.
That this is in terms of
Pendant.
Chamanlal.
Chamanlal, yes, my lord. Chamanlal and Jankinama, yes, my lord. In terms of the promotion,
Representation.
representation is
Annexure.
If my lord, Annexure 5 is forwarded to opposite part number 3 and 4, my lord. They have also stated that due to pendency of criminal case.
Pendency of criminal case, you cannot punish somebody. That too, no charges framed, whether charges are framed.
Charges framed were trial
The
has,
criminal court,
trial has not been commenced, my lord. But as per my instruction,
I'm asking you,
yes, my lord.
there is one judgment of the apex court, Hardeep Singh versus State of Punjab.
Punjab.
2014 Supreme Court. If charges are framed, then you become accused. Till then you are not. Therefore, I'm saying something in your favor.
Yes, my
So
lord.
that you will learn these things.
Yes, my lord.
Is it that?
Yes, my lord.
The GR case of 2019.
19, my lord.
So,
That even if charges are framed, how that is a ground for withholding these benefits? You consider the representation without ignoring the pendency of the criminal case. Who has to consider?
Your Malad, this is to OP number.
Representation is to the OP number 5, my lord, but it has been forwarded to OP number 3 and 4, my lord.
3 and 4 all.
Yes, yes, my lord.
OP number 3.
Short grievance of the petitioner is as to non-sanctioning of MACP benefit on the ground that the criminal case is pending against him. First off, Learned Counsel for the petitioner vehemently argues that the pendency of a criminal case is no ground for non-sanctioning of the MACP, which otherwise is sanctioned. First off. Next paragraph. Learned Counsel AGA, Mr. Mohanty, opposes the petition, contending that criminal case is pending, and during the pendency, ordinarily such benefits are not extended to the employees, so that the scrupulous conduct will be maintained in the campus. First off, having so contended, now he agrees with the suggestion of this court that the subject representation of the petitioner at Annexure
5, my lord.
Annexure 5 dated 19/7/2025 be considered, ignoring the pendency of the criminal case. Of course, subject to its outcome. First off, in that connection, all contentions are the multi-axle vehicle.
Yes, my lord. This is already, my grievance is already ventilated by the RTO, my lord. RTO already directed it to MCL. But in spite of that, not
You are
playing
by that vehicle on what road?
and that is in the transporting for coal, my lord.
Transporting coal.
Yes.
They are not permitting playing of the vehicle.
No, my lord. Already order was passed by our Annexure 4, my lord.
On what ground you were not prevent you?
There is no ground, my lord. There are only the old vehicles are 6-wheeler vehicles, my lord. The old vehicles. If these heavy vehicles are playing, then that is better, my lord. That's why they are old vehicles are playing. And in spite of that annex last agreement, the environment department specific that trucks of 40-50 capacity will be deployed for road sale for the reduce of the fleet size to further reduce emission, my lord. They already passed order, but not implemented by MCL, my lord.
No, not like that. The roads load bearing capacity.
Yes, ma'am. That is six
So
lane.
these things are important. Suppose there are pipelines and the sewerage lines and there are power lines. If they get damaged by the weight of the vehicle,
No, that is a 6 lane line, my lord.
huh?
6 lane is the road, my
That
lord.
exactly reflected in page 18, Milord.
Yes, my lord.
Under Indian Road Congress,
No, no.
there is a book, Indian Road Congress. You show me on what road, what weight laden weight vehicle can play. Show that. You can't just argue like this and go. It's a writ jurisdiction, writ court. Bring the Indian Road Congress, IRC.
My grievance, my lord. They already decided, my lord. Order passed, my lord, annex 8, page 18, my lord.
Annexure does not mention anything about Indian Road Congress. Supreme Court said, in more than 2 cases, where flying of vehicle issue arises, Indian Road Congress has to be kept in view. Bring that Indian Road Congress. Then I will be able to do something. Merely because you are saying, but that is the work of the lawyer. Researching is the work of the lawyer. Not reading some 2 provisions of Cattle Trespass Act and going away after getting some interim order. No, I will not grant order. that way.
There is no interim order, my lord.
Whichever order. Whether I want to dismiss the petition or you want to research and come back.
I will come back.
Counsel for the petitioner assures the court that he would do research on Indian Road Congress cattles and come back. First up, call this matter week after next. Okay. Lawyer should generate the habit of research. Yes.
Item 10.
My pleasure, Lords. The second round of litigation, my lord. Second round of litigation of the petition, my lord. It's a matter relating to appointment under rehabilitation assistance scheme. And the ground of rejection, Lordship, kindly see Annexure 12, page 36. While the petitioner's application was pending for consideration, the opposite party number 1 issued letter withdrawing the benefit of rehabilitation assistance scheme.
Withdrawing the benefit of
Rehabilitation assistance scheme. That is page 36.
this means appointment is withdrawn.
No, my lord. While pending application was pending for the government, my government issued letter that such benefit has been withdrawn. So there's
What were those benefits?
benefit rehabilitation assistance schemes. They are earlier giving Annexure 8 to some other persons, also private schools.
On which date it happened?
My lord, on Lordship may kindly see on 9th September 2020, and my application was pending since 2019. 9th September.
Take emergent notice.
Yes, my.
Issue emergent notice. The accused moment is requested to accept notice for OPs. Okay.
Notice to be issued to OP number 4 is a headmaster. 1 to 3 I can take notice. 4 is the independent notice.
Yes.
Item 11.
Fix a date because the rehabilitation since 2004 his father is dead.
Matter lies in a narrow compass. Therefore, post immediately after service.
Item 11.
May I please your lordship?
Final pension. Provisional pension is paid.
No.
That also is not paid. Take emergent notice.
Lordship.
The way it was request not to accept notice for the OPs. Possible. Matter lies in a narrow compass and it involves claim for pension. First half. Therefore, post it in the 3rd week of January. Okay.
Item 12.
Yes, sir.
Item 12, Lordship.
Yes, sir.
May please your lordship.
Yes.
Here the petitioner purchased a plot of land and a house from one Minakshi Padi. If your lordship will kindly see, permissions were also granted by the BDA for the earlier BDA plot for the said purpose. Permission was duly granted by BDA for the said purpose.
Yes, sir.
Now, Milords, they have issued a letter under Annexure 1 that
When the permission was granted,
permission was granted, Milords,
Before this cancellation order.
Before that,
Before that, much before that. Due permission was granted. Your Lordship, can you see Annex Chapter 7? Annex Chapter 7.
advocate is right. So a case is made out for issuance of emergent notice and retrieve as well. First, an application is moved. Mr. ASC Gray is requested to accept notice for OP number 1.
1, 4 and 5, my lord.
1,
4 and 5.
1, 4 and 5.
The rest to emergency notice.
Rest. Next first. An application supported by in IA number 5, so supported by affidavit is moved, seeking review against the notice. A framework is made out in as much as the sanction was accorded earlier. Therefore, notice of the claim could not have been issued. First one. Next one, in the above circumstances, the subject application is pulled off, staying the operation of include notice dated 8/9/2025, copy thereof, as the next A1, and all further proceedings pursuant thereto. First, since ex parte order is made, next one, it is open to the other side to move its rescinding or variation. If grounds do exist, therefore. Yes.
Item 13.
Your Lordship,
Yes.
this item pertains to the issuance of wrong provisional grade sheet by the Office of the Controller of Examination of Sambalpur University for MPhil program in Home Science.
Wrong provisional certificate.
They have issued an incorrect one.
It's incorrect certificate.
They have
What is the
omitted
wrong in that.
They have omitted the research and publication ethics paper from the grade sheet.
That
Which
paper is not included.
Yes, sir. Annexure 5, page 15.
Take notice.
We are on behalf of Mr. Guru, we are appearing for Sambalpur University and we will obtain instructions by him.
Issue emergent notice. ASC Ray is requested to
For one.
notice for 1. OP numbers 2, 3, 4, 5, and 6. No, you appear for
Six also. Heads of the department.
rest of the OPs are represented by their panel counsel Shri so and so.
लिखी दे दो, चिट्टे दे दो.
First up, panel counsel seeks some accommodation for filing the objections. First up. Next, matter lies in a narrow compass. Call the same in the second week of January 2026.
Short date may be given.
Generally, the judge is not supposed to fix the date except in very important matters.
Lordship is facing difficulties in pursuing higher education.
No, January second week we'll have that. In the first week we'll have that. First week of January. Okay. If in the meanwhile, if objections are not filed, petition will be taken with face value. Okay.
Item 14.
Yes.
May it, Mr. Lordship.
Yes.
This matter, my lords, my grievance is against the order under Annexure 1. A person junior to me has been appointed as principal in charge. That is at page.
When that appointment happens, sir?
That
Contrary to rule 8.3.
No,
Huh.
here, my lords, there is no rule for appointment of principal in charge. Government has issued instruction under Annexure 18 and 19. Pursuant to that recommendation in Annexure 20.
Senior most will be the.
Yes, that was recommended in Annexure 21. Well, I have been shown as the senior most person. Now they are
notice. Show emergent notice. Mr. Ray, Lovely DSC. Notice for P numbers 1 to 4. Emergent notice to 5.
Item 15.
May I please? The petitioner is a level 5 ex-cadet teacher. My lord, he passed OTT examination on 21/11/2019. The government issued a notification under Annexure 5 that saying that those who have qualified OTT examination after 31/3/2019, they will get annual increment on notional basis with effect from 1/3/2020 and on actual basis with effect from 1/3/2024.
That's not given to you.
That has not been given to me. I have made a representation to the district education officer under Annexure 6.
Consider that representation at Annexure 6.
Annexure 6.
Annexure 6,
Page
being a
21.
view Annexure 5, that government notification.
Short grievance of the petitioner is as to non-sanctioning of the financial benefit that would accrue on his acquiring a particular qualification, namely OT-AT.
OT-AT, Orissa Teacher Eligibility Test.
OT-AT, which he claims to have obtained on 21/11/2019.
Yes.
First off. Next paragraph. Learned counsel for the petitioner draws attention of the court to his client's representation dated 24/6/2025, a copy whereof awaits at Annexure 6, which needs to be considered in the light of Annexure 5 government circulars.
Government notification dated 4/2020.
Notification dated 4/3/2024.
Yes.
24. First off, he adds that if a direction is given to consider the subject representation, justice would be met to his client. First off, next paragraph. Learned ASC appearing for the OP, although initially opposed the petition, now graciously agrees to instruct OP number 3 to look into the grievance of the petitioner as has been aired in Annexure 6 in the light of government notification at Annexure 5 within a reasonable period if all contentions are kept open. First off, this is absolutely fair. Next paragraph. 6 weeks.
Yes.
Open to solicit. Now no course.
Item 16.
But in item 16,
Yes.
the petitioner was engaged as cook in Gopinathpur High School on 2/4/2005. But she was removed from service on 8/8/2025. She has made a representation to the district education officer under Annexure 6.
Why she was removed?
But she was removed on the ground that her husband was a member of the school management development committee. But in fact, her husband has resigned from that post. That is Annexure 3.
He resigned thereafter, my lord. His after selection he has resigned.
She was temporarily engaged as cook. When question came up for consideration of her case on regular basis as cook, but the development committee passed a resolution, but that resolution was not acted upon. Thereafter, her husband has resigned from that post. And after that, the school management development committee sought for instruction from the district education officer what to do in the matter. And accordingly, a resolution was passed. But that is pending with the district education officer.
Okay. Consider that representation.
Yes.
Annexure 6, my lord, page 22.
Petitioner was earlier working as the cook. First time. She came to be disengaged from service. Kindly be seated.
Yes, sir.
On the ground that her husband was a member of the school management development committee. First time. However, counsel for the petitioner submits that the husband resigned from the position on 23/7/2025, and thereafter a representation dated 15/9/2025 has been made to the director of the district education officer to consider her claim for re-engagement in the changed scenario.
OP number 3.
That's the first term. Learned counsel for the petitioner submits that if OP number 3 is directed to consider the subject representation in the changed circumstance, his client would be happy. First term. Next paragraph. Learned ASC, Mr. Ray, appearing for the OPs, opposes the petition, contending that as on the date the termination from engagement happened, the husband of the petitioner was the member, admittedly a member of the school management school development committee, and therefore termination cannot be faltered. First off, having so contended, now he agrees to instruct OP number 3 to look into the grievance of the petitioner as has been aired in the subject representation within a period of 8 weeks. First off, He caveats that all contentions of the party should be kept open. First, with this proposal, counsel for the petitioner is agreeable. Next paragraph. 8 weeks.
Item 17.
May I please, my lords. I may be permitted to appeal to virtual matters.
Issue notice. ASC. Ray accepts notice for office.
Item 18.
May I please?
Yes.
Well, here the petitioners grievance before Lordship that the opposite party, they have unilaterally refixed the pay which was fixed earlier in 2016 by considering that since the petitioner, after acquiring the training qualification, his pay was upgraded to actual scale of pay meant for the post, that is one promotion. Therefore, they have revisited the fixation of pay and also refixed the date of next increment.
Let them consider your
Representation that is
at Annexure 6.
Annexure 6, that year.
Okay.
That is pending.
Okay. The short grievance of the petitioner is as to non-consideration of his representation, his or her, his representation for modification of RACP and 7th pay fixation order earlier sanctioned by the DEO Jagat Singh Pur. First off, counsel for the petitioner submits that when a representation of the kind is paid, there is a constitutional obligation resting on the authorities via Article 350 to give redressal to the grievances aired by the citizens. First off, learned ASC, Mr. Sen, very fairly agrees to instruct OP number 3 to look into the grievance of the petitioner as has been aired in the subject representation, a copy whereof awaits at Annexure 6 within a reasonable time if all contentions are kept open. First off, this is fair and reasonable. 8 weeks. Next.
Item 19.
Regarding the RSV matter, similar matter is already discussed. All the similar matter.
All similar matters.
Yes, my lord. Only change the petitioner name and
Item 20.
The petitioner is a retired junior clerk cum typist of Mahatma Gandhi Memorial Higher Secondary Education. He is challenging the inaction of the opposite party number 3.
Challenging?
He is challenging the inaction of the opposite party number 3, for not accepting his application for one-time cessation benefit or neither considering it. One-time cessation benefit as decided by the government of Odisha under Annexure 3.
There is a policy. Is there a policy? One-time cessation benefit to block grant employees.
Annexure 3, page number 23.
Okay. You have given the representation.
Yes, my lord, under Annexure 5,
page 33.
Page 33.
Petition prayer reads as and done.
My lord, with a view to order dated 25. Order dated 25/24 in WPC number 10087 by 24, with no bar to accept my request or consider my application.
There is a judgment. It supports your view.
No, actually in WPC number 10087 by 24, this honorable court has quashed this order. And the rate of appeal is pending, my lord. But this petitioner is not a party to that WBC number.
But take notice.
Yes, my lord.
Issue. You are very fair. I appreciate that. How many states of Odisha are there in this state? Why you have implemented two states of Orissa?
करेक्ट कर दो
Go to your
दोन और
first state.
कॉस्ट है कॉस्ट है स्टेट ऑफ ओडिशा बीटा कर चलो
State of Odisha. One.
Sir.
Two is also state of Odisha. Some officer should be made. Issue a commission. So the DAC is requested to some notice for 124, emergent notice to 5.
Item 21.
May I please, Your Lordship? My Lord, limited grievance. My Lord, the petitioners are working as tailoring teachers under the department.
Tailoring teachers.
My Lord, under the Department of ST and SC Development, my Lord. My Lord, they were initially appointed on 21/2/1999. My Lord, and they're praying for the
21
fixation.
February 99.
My Lord, they're praying for the fixation of pay in the pay scale of rupees 1,080 to 1,800, my Lord. My Lord, matric CT and PET teachers having requisite qualifications were granted the pay scale of 840 to 12. My Lord, they were getting the pay scale of 840 to 1,240, my Lord. My Lord, including the tailoring teachers as well as the vocational teachers, other vocational teachers, my Lord. My Lord, upon the introduction of ORSP 1989, my Lord, the physical education teachers were revised to the pay scale of 975 to 1,660. And my Lord, the matric teachers were placed at the pay scale of 1,080 to 1,800, my Lord. My Lord, later on, the physical education teachers were also
3,600 to 5,600.
No, my Lord.
But you have written that one. Kindly come to page number 10.
My Lord, that is as per the ORSP rule 1998. That is the scale of pay as per 1998 ORSP rule. My Lord, that is in the pay scale of 1,080 to 1,800 only.
Mr. Behra, take note.
My lords,
My Lord, similar matter.
my lords, in some cases, on representation it was considered and benefit was granted. I have seen some cases.
My Lord,
Direct
I have
consideration of the representation.
That will serve.
annexed the similar.
Any similar matter is judgment is
My Lords.
Page 21.
The subject matter of this petition is substantially similar to the one treated by a coordinate bench of this court in WPC 20224 of 2021, my lords, between Chandrasekhara Party versus State of Odisha, heard and disposed of on 19/7/2021.
May I pray one thing, my Lord? May I pray one thing, my Lords? My Lord, similar teachers were, similar cases of similar teachers were considered in OA number 1914 of 2018 and subsequently my Lords, OA number 1914 of 1998.
Where is that?
My Lords. My Lords, Annexure 2 and Annexure 3, my Lord. Annexure 3 is the order of implementation, Annexure 2 is the order, my Lord.
Counsel for the petitioner draws attention of the court to the government office order number 19770/SSD dated 16/11/2019 at Annexure 2, which implements the order of the Orissa Administrative Tribunal in OA number 2536 of 2016 between Sri Shyamasundara Mishra versus State of Odisha, disposed of on 31/7/2018. First, he argues that in view of all this, similar benefit needs to be extended to his client. First off, Next paragraph. Learned AGA Mr. Behura, appearing for the OP, opposes the petition, contending that certain disputable fact matrix is involved, and therefore at the most court can direct the concerned officers to look into the grievance of the petitioner as has been aired in the representation dated.
There's no representation.
No, it's there.
Annexure 6, madam.
Date here, dated the 6/10/2025. A copy whereof awaits at Annexure 6, which has been presented to the District Welfare Officer Sundargarh. First off, Mr. Behura submits that all contentions of the party should be kept open and a reasonable period be accorded for accomplishing the task. First off, with this proposal, counsel for the petitioner contends. Next paragraph. 6 weeks. Open to solicit.
I can put
No,
May I please, Your Lordship?
Yeah.
Lord, in this case, the petitioner had joined as a retired physical
By
educator.
2010.
Yes, Your Lordship. That is the
Similar
date.
matters we treated the other day. That
And my representation is pending at Annexure 5 series with the opposite party for District Welfare Officer Raigada.
do we have that judgment which we have?
My Lord, there is a division bench judgment of 2003, my Lords. This is 2003 2 OLR 321, which was followed by the Honorable Coordinate Bench in WPC OAC 3770 of 2017.
Identical matter.
Yes, Your Lordship. With regard to.
But effective date is 2019 year. But you are referring to older judgment.
My Lord, 2003 judgment has explained the concept of what is the intermediate art CPET scale of pay. Then the subsequent judgment is of the year 2024. The number is of the year 2017. That division bench judgment has been referred to, Your Lordship.
That Niranjana Naik.
Yes, Your Lordship. Niranjan Naik has been referred to in Kanhu Charana Palta Singh, Your Lordship, by the Honorable Coordinator.
So if your case is considered in the light of Kanhu Charana.
Kanhu
Charana.
Yes, Your Lordship. Yes, Your Lordship, if my Lord may direct that.
Mr. Behura.
My lords,
Today I said similar matters to consider.
my lords.
I don't remember that.
My lords may direct consideration of representation at page 23.
Yes. Short prayer of the petitioner is as under. First off. Before approaching the court, he had given a representation dated 25/6/2024, a copy whereof avails at Annexure 5 series. Copies whereof avail at Annexure 5 series. First off, the short representation reads as under. Next paragraph. Learned counsel for the petitioner submits that in the light of coordinate bench decision in WPC OAC number 3770 of 2017 between Kanhu Charana Palta Singh versus State of Odisha, disposed of on 6/2024, the subject representation is entitled to be considered at the hands of
the OP Party 4, Your Lordship, District Social Welfare Officer.
OP number 4.
Yes, Your Lordship.
OP number 4. And if such a direction is given, his client will be satisfied. First. Next paragraph. Although learned AGA Mr. Behura initially opposed the petition, now very fairly agrees to instruct OP number 4 to look into the grievance of the petitioner as has been aired in the subject representation in the light of Kanhu Charana case Supra. If all contentions are kept open. First off, he also requests for prescribing a reasonable period for accomplishing the task. First off, next paragraph. Consideration to take place. Consideration of the representation to take place in the light of the coordinate bench decision in Kanhu Charana Palta Singh. Something like that. All conditions kept open to solicit. Okay. Item 23.
The petitioner is working as a contractual ATO
in government ITI Berhampur since 2006. Thereafter, he was brought to there is a part-time guest instructor. Now he is continuing till now. But now the annexure 4, the opposite part number 2 has issued a circular, that is there is notification to fresh selection for guest instructor minor. That's why your lordship see annexure 5, this is continuing till now. Now
how long you have been continuing?
How long is 2006 onwards till now? That is 19 years. Then the regularization part is also under consideration, is pending. Now only the guest instructor, if the fresh selection will be done pursuant to the advertised notification that for annexure 4, then he may be ousted or he may be deprived from the job, my lord.
So, 1 second. Whether that notification is also for guest lecturers?
Yes, guest instructor. Yes, your lordship, see, that is I am reading out. That is in accordance with the approval of the Dictatorial Department, accordance with the search, with the orders obtained in Finance Department by so and so.
My lord, yesterday passed orders in similar cases.
Issue emergent notice. Shri Behura is requested to accept notice for OPs. Next part. The Net Counsel for the petitioner submits that one set of guest lecturers cannot be substituted by another set by undertaking fresh appointment process. First off, he further submits that if the impugned order is not stayed, the same would prejudice.
My lord, stay in respect of one year, my lord.
First, he draws attention of the court to application in IA number so and so, supported by an affidavit in this regard. First off, there is force in this submission. A prima facie case is made out for deeper examination and for issuance of reprieve. First off, IA having been favored, petitioner is directed to be continued as the guest instructor with the usual terms as are applicable to him. First off, however, the process under the subject notification is not halted. Okay.
Status quo.
You are continuing.
Yes, my lord. Allowed to continue. Published.
Okay.
The course of the day we copy because.
Yes. Print it first. Okay.
Item 24.
May it please, my lord. My lord, these are pension matters, my lord.
These connected matters are pension matters?
Yes, my lord.
What's the issue in what?
My lord, issue is that after retirement, though they have represented, till date no pension has been extended, whereas similar situated employee I have extended with the pension, my lord.
You take emergent notice?
Yes, my lord.
Or you want consideration of the
No, my
representation?
lord, representation won't be of any help.
Okay. Issue emergent notice, Behura for 1. Emergent notice to 2 and 3. Who is the counsel, panel counsel?
My lord, many councils are.
Anyway, emergent notice 2 and 3. This matter lies in a narrow, these cases lie in a narrow compass and they involve claim for pension. Post the same in the third week of January 26.
Item 25.
Yes, sir.
Petitioner is, my lords, aggrieved by an order of transfer under annexure, my lords, 3, page 21.
What is he?
He is the lecturer in political science and is the approved principal in charge of Pateshwara High School, Higher Secondary High School.
Pateshwara Higher Secondary. There are most of lecturers. In high schools also.
Continuing higher secondary Indian college in Juniper. Now the order has been issued by the director. Your lordship will find director higher secondary education. So I am assailing the order of transfer on 2 grounds. One, my lords, the director of higher education and higher secondary education has no jurisdiction power to, my lords, transfer me because my conditions of service are controlled by the director higher education. This is pursuant to a notification in 2016, on 6/10/2016 to be precise. That is at page 15, annexure, my lords, annexure 1 series, page 15. I'll just draw your lordship's attention to this annexure.
It's serious. Another connected matter is there. Let it listed along with that.
No, that I have my reservations in that submission. That will be an aid to arguing this matter. Your lordship may, in your lordship's wisdom, ultimately in your lordship's discretion, may tag it up. But I am praying here.
Well, call this matter along with that matter.
I have an emergent interim order here.
Tomorrow.
Lordships. In the other matter, the financial powers of this gentleman has been seized. So they have been challenged by your lordships, and lordships have been pleased to issue notice here.
Normally not hold inquiry in every.
No, need not.
Suppose we don't want to hold inquiry, and we will post you to some other person. Suppose I feel we are not happy.
Very well, madam. I don't join issues on your.
We will call this matter tomorrow.
This one is matters without jurisdiction.
Let us see.
That is the.
Let us see.
So tomorrow minutes.
Tomorrow along with the 50 number.
Tomorrow.
Let it come along with 8598 of 2015.
Second.
Yes.
Which is that?
I'm referring to the governing body. There also, this order was issued because of this direction. Court has directed the coordinator directed the director to pass a law.
Well, I don't know.
Day after tomorrow.
Day after tomorrow is what?
Don't trouble him till then.
Well, till then, I need not be troubled.
If not relief, my lord. If not relief.
He's not governor.
Because already my instruction.
Let us see.
He has already been relieved.
No, that is no ground for granting, for refusing his moderate.
Months.
If we relieved, we direct him to be reinstated. Yes, call this matter day after tomorrow. Sorry.
In the meantime, status quo minutes.
Let us see.
Months.
Next week.
Unless they are going to push me out. By force. My lords.
Nothing will happen.
None.
Sir. Dispose of that.
Lordship will record my appearance.
Yes, heard. Sorry. No, Mr. Behra is requested to accept notice for OP numbers. So Mr. So appears for management OP number. So all this matter of other connected case in WP number. So as suggested by Mr. Behura and also by the panel.
Some form of protection, my lords. Some form of interim protection, otherwise day after tomorrow it might become infraction. If they push me out, some form of interim protection because I am before the High Court.
So and there also that
let my friend
that was financial
already appointed
financial for the time.
Any caveat is fine.
Yes, caveat was filed in
the other case.
In this case, no caveat is status quo till next day.
Okay. Yes, sir.
Item 26.
Here the petitioner was working as lecturer in electronics since 1991, and in the meantime, he has already 34 years of service he has already rendered. Now, my lord, she has convicted in a criminal case for which the appeal is pending, Annexure 4. Now the Annexure 5 has been issued. Based on the conviction, now the dismissal for so cause has been issued. But I am relying that Tulsiram Patil case, based on that, a number of on different high courts have also decided that the conviction in criminal case, not a automatic dismissal from service, the automatic dismissal, not automatic. The authority has to consider the conduct as well as the
conduct. Suppose if he is in prison, he is serving there, and still we should retain him in the service.
No, only 1 year service left.
That is not. Only 1 year service is left, and therefore yesterday I went to Cuttack back for robbery.
That I know, man. In the Tulsiram Patil, that provision I am relying on protection because I am relying the number of judgment. And your lordship dismissed one matter before the Karnataka High Court Division Bench. That in that case, your lordship did not interfere only on the ground that criminal appeal already dismissed in that case. But here in the criminal case, appeal is pending.
Correct. Appeal is pending. Whether conviction is stayed?
No, conviction is not.
Then what? Then Navjot Singh Sidhu versus that applied to you. Which is that judgment? Navjot Singh Sidhu.
Yes, Sarin. And
Supreme Court. The principle of that Tulsiram Patel, that Article 311 second proviso, when it will apply and dismissal, conviction of the criminal case is not automatic dismissal from service, the authority has to consider. That is my submission. But only but
where is my judgment?
Yes. I have researched all the judgment. I also wrote one judgment, Karnataka High Court single page judgment. He also in favor, in my favor.
In one matter I dismissed, your own matter I dismissed, I remember.
No, not my matter. This is your lordship division bench judgment. On the ground, your lordship did not interfere. That criminal appeal has also been dismissed in that case. And now Allahabad High Court recent judgment.
If you succeed in appeal,
yes.
Suppose if you are dismissed on the ground that you are convicted in a criminal case, and the criminal case is set aside, conviction is set aside, they have not held any disciplinary inquiry, then you are entitled to...
Inquiry is pending against me. DP is pending against me.
DP is pending?
Yes.
Now that question will not arise because
conviction is there. Then my next submission, madam. Even if at all, I acquittal in the criminal case. They still they have the authority to independently decide my DP.
Correct. Once you are convicted, they need not hold inquiry at all.
Therefore, madam, they have to consider the conduct as well as the past service. This will also kindly see. The recent judgment, if you are Allahabad High Court as well as the Karnataka High Court.
Karnataka High Court also?
Yes, the single bench judgment is also kindly see.
Single bench?
My lord.
But that ignores our division bench.
No, that decision, my lord, you also judgment, only criminal appeal dismissed. But now I am relying that Kamlesh Kumar versus State of UP, that is decided on 23rd July 25, recent judgment.
What is the offense you are convicted for?
PCI, well, vigilance case.
PCI. So which is that section? There is one provision. Lily Thomas versus so and so, which is the judgment of the apex court. Take out Lily Thomas versus so and so. You just look into and come back.
Yes.
You call this matter after 2 weeks.
No, lordship, I consider lordship. I have experienced every in the present case, my lord. And I have relied to judgment which by the past with different high courts. Madhya Pradesh High Court also I am relying, and Himachal Pradesh High Court also I am relying. In a similar context, that no automatic dismissal. And only was next January, only 1 year service left.
My lords, this is not automatic dismissal, my lords. This is a show-cause notice to...
And then they have done it.
No, my lords, he has challenged the show-cause notice.
Yes, show-cause for dismissal. Yes.
You file your reply.
That is also notice is given to you.
Yes.
That is why you reply to that in the light of all this.
You also may observe that.
Okay. Petitioner who has suffered conviction and sentence punishable for offences punishable under the provisions of PC Act 1988, he is knocking at the doors of writ court for assailing the show-cause notice dated 15/11/2025, a copy whereof awaits at Annexure 5, asking him to show cause why he should not be
dismissed
from service on the ground of conviction. In the light of KC Sarin, DBI.
My lord.
KC Sarin versus CBI. Criminal appeal number 940. Which is that KC Sarin?
Yes, that is
6 HC 58. First. The net counsel for the petitioner, who usually does lot of research before making submission, argues that merely because an employee is convicted and sentenced to undergo imprisonment, the vinculum juris of employer-employee is not disrupted. And therefore, the show cause notice is unsustainable.
Criminal appeal is pending and
First off. He also draws attention of the court to the pending criminal appeal number 946 of 2025 against the order of conviction handed by Special Court.
Special Court Vigilance.
Special Court of Vigilance. First off. Next paragraph. Learned Counsel, Learned AGA, Mr. Behura, appearing for the OPs in his usual style, opposes the petition contending that when show cause notice is issued, the best course open to the litigant is to show cause against the proposed actions, taking up all contentions which are in the writ jurisdiction, so that a meritorious decision would be taken by the competent authority on that basis. First off, I agree with this proposition. Next, in the above circumstances, petition is disposed of, reserving liberty to the petitioner to show cause to the subject notice dated 15/11/2025 within a period of 2 weeks. First off, in that section, all contentions are kept open. Only because you commit a lot of research, I have interfered in this matter this week. Otherwise, generally, he's Mr. Swain, I appreciate. He's a growing lawyer. It's a growing lawyer.
The authority may consider the judgment for land.
Yeah. The authority shall consider all contentions, including the rulings which the petitioner is going to sign in his reply to show cause notice.
Item 27.
May I please note?
Yes, sir.
Petition of Lordship is a pre-order. And the government revised the RSCP from time to time. In the last RSCP revision is Annex 7, page 18/1/2017. And that benefit has not been given to the petitioners. Even though that is all
entry level.
18/1/2017, Annex 7.
No, in your prayer.
Yes. And that benefit, that revision scale, that has not been given to me, though that was given to others. And another case, in the same cases, even after retirement, the controller accounts made an objection saying that no, whatever you are giving, that is wrong. You should give according to 18/1/17 government circular. The final divided circular, that is circulars. And you also kindly see Annex 4, 5, 6, time that was revised by the competent authority from the beginning 5, then 6, then 7. And 5, 6 that was given. And so far as 7 Miller, that was not given.
Take notice. Behra accepts notice for this. Matter lies in a narrow compass posted in the second week of January 2024.
Item 28. It's a lady, my lord, working as a teacher in Taljuri Upper Primary School, Loisingha Block, in district of Bolangir, my lord. She joined in the year 2028, my lord. 18, my lord. 2018, my lord. 7 years are completed, my lord. And she belongs to Brahmagiri Block, district of Puri. After her marriage, she is residing with her husband at Bhubaneswar, my lord. Thus, she make a representation annexure 4, my lord, at page 3 for transfer from Bolangir district to Puri or any other nearby district, Khorda. In the meantime, what happened, my lord? Kindly.
Petitioner's short grievances against non-consideration of her representation dated 14/8/2025, wherein she has sought for transfer from which place?
Taljuri Upper Primary School, Loisingha, Bolangir district.
Tell it slowly. Yes, thank you. From
Taljuri Upper Primary School,
Loisingha block in the district of Bolangir.
To Bhubaneswar or Puri, my lord, any
nearby school in Bhubaneswar or Puri, where her husband has established the matrimonial home after marriage. First off, the counsel for the petitioner presses into service the decision of the apex court in Orissa, state of Karnataka, in support of his contention that once such a representation is given, the authorities are duty bound to look into the same and grant redressal in accordance with law. First of all, next paragraph. AGA Mr. Behura, on request appearing for the OP, supposes the petition contending that no employee has a right to be transferred to the place of his or her choice, and therefore writ petition is misconceived. First of all, having so contended, now he agrees to instruct OP number 2 to look into the grievance of the petitioner in the light of the subject representation, if all contentions are kept open. First off, this is appreciable.
One line submission, madam.
Yes.
Annexure 5, page 25. OP2 already taken a decision for interdictory transfer, madam. My representation shall be considered along with the Annexure 5, madam.
In the above circumstances, petition is disposed of, directing OP number 2 to consider petitioner's subject representation in the light of
letter 28/11/25
28/11/2025 addressed by the Director, Elementary Education, Odisha, to all district education officers of the state regarding completion of online intra-district transfer of teachers working in government schools. First, this should be a period of 6 weeks.
Last date is
to solicit information, etc.
Last date mentioned 25 December, madam.
25
December. Last para, madam.
Before the cutoff date of 25/12/2025.
Item 29.
Matter relating to grant of first RSP and second RSP. Similar material or also I have corrected.
Yeah.
The first RSP and second RSP including grade payment.
Yeah.
My prayer may be quoted to your also. I have already corrected.
Prayer.
Item 30.
May I please?
Yes.
My lord, the petitioners, after facing due process of selection, they were engaged as Sikha Sahib way back in the year 2003. They have already put in more than 22 years of service. Now, your lordship may kindly turn to Annexure 4 at page 25. Now, they have been disengaged from service, relying upon the judgment of this honorable court. In the case of Hushikesh Bindhani, this honorable court has held that where, my lord, the engagement has been made beyond the advertised vacancies, those appointments are declared bad. But as far as the petitioners are concerned, and my second point before your lordships is, since they have put in more than 22 years of service, before passing the order of disengagement, at least even as per their scheme, their circular, they are entitled to get a notice. Though notice has been issued, straightway, unilaterally, this order of disengagement has been passed. And similarly situated teachers, after completion of 6 years of service, my lord, under Annexure 6, their services were regularized as regular primary school teachers. One thing is that here some cases are pending before this honorable court, and the petitioners also filed one WPC number, that is 4703 of 2007, and that was disposed of. But some other counsel was there on the ground of no instruction on 19/6/2025.
But suppose to give effect to the order of the apex court, if some decision is taken, how to halt that such kind of?
Well, my submission before your lordships is,
our case is not hit by the judgment of Hrusikesh Bindani. So your lordship may examine this point. I have categorically stated that we are not engaged beyond the advertised vacancies. And
how many vacancies were advertised and how many were appointed?
You lordship may kindly see the advertisement. That is in vernacular, Odia. Annexure 1 has is 16.
Yes.
So far as Bhanjanagar education
vacancies notified?
Notified is 245 in respect of Bhanjanagar education district.
How many were appointed?
My lord, 245, sorry, 245, and out of 245, 40 posts were earmarked for SC candidates and 55 for ST candidates. Here, the petitioner number 1 and 3, they belong to ST category. Petitioner number 2 belong to SC category. So they were within that reservation.
Now, how many were appointed?
Well,
as against 245.
As against 245. Well, that data is not with me.
The data is necessary. How many vacancies were notified? How many were appointed? And whether the quota was exceeded? These people.
Yes.
We exceeded the quota.
Yes.
All that necessary information you have to.
Well, that information is available with the state government. Because you will also may kindly see, there was an advertisement. We participated in the selection process. We were given engagement in 2003. And
all that looking into only that judgment has been issued.
Yes.
My lords,
another
annexure 4.
Just wait. Well, a coordinate bench of this honorable court, exactly in a similar case, you also may kindly see that judgment. They were also, well, that case is an extreme case because that case is an extreme case because in that case they were engaged beyond the advertised vacancies. Well, I may kindly see paragraph 11. Paragraph 11 of that judgment.
The question is not very simple. They were in excess of the quota. That they would.
Yes. Yes. But my specific averment is, but we were engaged within that advertised vacancies, within that quota, meant for SC and ST. So let them take instruction and apprise your lordships.
Take notice.
My lord.
But don't relieve them.
Yes.
Nothing is going to happen.
My lord, what I humbly submit, my lords, this annexure 4 is passed pursuant to order of this honorable court.
Correct.
In compliance.
4 is in accordance with judgment or not, I have to examine.
My lords, that will file by counter.
Till then, I don't disturb. That is
that again will hold the order of this honorable court.
Suppose the apex court upholds conviction and sentence of hanging. Can you hang him to the nearest tree? Suppose you want to take him saying that apex court has dismissed his criminal appeal, SLP, and therefore he is convicted for offense of murder.
Why
the execution has...
Why I am submitting, my lords, let me file counter, then if he is entitled to...
No, that is not that simple.
Because
all these years, it is not very fraud or something like that.
Maintaining their livelihood.
My lords, 2 years. My lords, 6/11/2025.
Yes.
They have disengaged.
No. It is
take them back. Nothing is.
It is 6/11/2025.
It's all right, but take them back. Nothing is done. All of a sudden, see if they are removed. To come to the court, they take some money.
Submit one thing. My lords may call this after 2 weeks. My lords will try to file, because suppose they have exceeded the...
Then they will go home.
Yes, my lords. So for this period, again,
how you will be affected? If their services are continued,
no, my lords,
how they will be affected?
Because, my lords, we have to obey the order of this honorable court and apex court's order.
Correct.
That is
nothing like that. Correct. Issue emergent notice. Heard Mr. Swain for the petitioners. Issue emergent notice. First, Mr. Drawing attention of the court to the application in IA number so and so supported by the affidavit submits that the engagement of his clients, engagement of the services of his clients was within the quota prescribed for SC and STs at the rate of 20% plus 55, at the rate of 40 and 55 posts.
Yes.
As against the 245 notified for recruitment.
Yes.
Recruitment. First off. Unless this aspect has been deeply examined and equities are adjusted, snatching away job of these poor people, especially belonging to the downtrodden community, would drive them progressively into greater Bombay Corporation versus Swine. So 82 Supreme Court, something like this. First. Learned AGA Mr. Behura vehemently opposes the application, contending that when disengagement is the result of a decision of the apex court, maybe as an incidental, ordinarily the writ courts should not grant any reprieve. First off, he also tells the court that a short accommodation may be granted so that the counter would be filed and matter itself can be heard and decided finally. Next paragraph. Having heard both the sides and having perused the petition papers, this court is inclined to allow the subject application by granting a reprieve. It is not a case of fraud or fabrication alleged against the petitioners. First off, 245 posts were notified for recruitment. Wide notification dated
25/3/2003. It was published in the local daily, the Sambaad.
25/3/2023. 25/3/2003.
Yes.
And thus, more than 2 decades they have been in service.
Yes.
Of them, 40 were earmarked for the SCs and 55 were earmarked for the SCs. Thus, there is a case for deeper examination as to whether the appointment of these petitioners was in excess of the prescribed quota.
Yes.
First, no prejudice would be caused to anyone if petitioner continue in service with the same terms and conditions. First, if not continue, their bread winning will be at stake. Come on, to say the least. First, thus Olga Telis comes to the aid of petitioners. First, in the above circumstances, application having been favored, OP number
3. Collector. This order has been passed by the collector.
OP number 3 is directed to continue the petitioners in service till next date of hearings. First, non-compliance of this interim order may result into striking all the defense that may be taken by the OPs.
My lords, this seems it is related to Chhatrapur.
No.
It was submitted that it is Bhanjanagar. Oh, where it is?
Bhanjanagar Education District.
Yes. Well, just because for last 20, more than 20 years they have been working. You can't unceremoniously send the people. We have worked. There is no fraud, fabrication, etc. But as you rightly said, decision of the apex court. That I will examine. I'll come back within a few minutes.
In this rather the inaction of the opposite party in not complying the order dated 37/2025 manner, in double piece number 20/361 of 2025 manner. Your lordship directed to opposite party to comply the order in a stipulated period of 6 weeks.
So there are
My lords, I see that.
Where I requested also for this. For OPs. First, there is a prima facie non-compliance of the order. First off, if compliance is on the next date of hearing, stringent action may follow, which may include arrest and detention of the officials.
Annexion 9. The order passed by the appellate authority has not been complied by the OP number 3, the DU, Court of Milan.
That order was passed when?
Passed on Annexion 9 on 23/2025. On 23/2025.
Who is that officer who should comply with?
Comply with DU, OP number 3, my lord.
To that notice. Mr. Behura is requested to have notice from OPs. First off, the prima facie case is made out to show that DU is not following. We should
DU.
The DU is not obeying the order of Director of Secondary Education.
Yes, my lord.
Secondary Education made on 20 March 2025. First off, this is a serious matter. First off, call this next week. Next week, Mr. Lenka?
Yes, sir.
I will direct his arrest and detention.
No, you not. He has to challenge the annexure.
There is an order by the higher officer. They have to obey that order.
No, now he has challenged that order. Higher authorities order. Annexure 9.
No.
Yes.
No, he is complaining that this order has not been complied with.
No.
I am with agreement with this order.
I want kindly read a prayer. Come to the prayer.
Yes, ma'am. Why the orders passed under Annexure 7 and 9 by the opposite party number 2 and 3?
Although, my lord, I am challenging the order passed by the disciplinary authority as well as the appellate authority.
Yes.
The order passed by the caller, I have considered the order of the appellate authority. I only pray before my lord to comply the order within a time frame.
But that is not the
But your prayer is a bit different, as he rightly points out.
Yes.
I am not pressing my prayer of challenging the
recall that.
Yes. I am only prayed to comply the order within a time frame. My lord.
Passed by the appellate authority.
Passed by the appellate authority.
You comply with that?
Yes.
Petition prayer reads as an. Now, counsel for the petitioner submits that he is happy with the order dated
20 March
2025 passed by the Director of Secondary Education, Odisha, Bhubaneswar, a copy whereof avails at Annexure 9 and that the district education officer Cuttack has to comply with this order.
Yes, ma'am. OP note 3.
First one. Mr. Lenka, on request appearing for the OPs, agrees with the suggestion of this court to instruct the said OP,
DO3, OP3.
OP3, to ensure compliance of the said order, subject to all just exceptions, within a reasonable time. First, ordered accordingly, and writ petition is disposed of. Time for compliance is 4 weeks.
Yes.
Item 33.
Yeah. That's it. This is a matter was before your lordship yesterday. And your lordship wanted to know whether the continuing service or not. Now he is continuing in a society, that is SAM society, under the Higher Education Department. That society is registered under the Society Registration 861. That is continued.
Registered by whom? Society is formed by government?
Government.
So it's Article 12.
Yes. That's why it is mentioned.
It is continuing itself without any remission or anything, sir. Apart from that, we are requesting to Honorable Court for the stay till the dispatch of this writ.
So far, regarding the stay petition is concerned, my lord, they should make some inquiry that the offense, the findings of the ICC does not constitute an offense under Sexual Harassment Act. That your lordship may kindly see the provisions of the act. That is.
Now, what the report says?
The report says that he is found guilty under section so and so.
Guilty of what?
Sexual harassment.
But the WhatsApp messages which he has sent, kindly see them.
Yes.
And they shared sought for money.
No, she has. That part is there. But other part also
the money.
Let's see, actually,
asking the question.
After that only they file this case.
That is his case. But your lordship is
it is her case also. It is her case also. She is a colleague. He is a professor, she is an associate professor, something like that.
Subordinate to him.
Correct.
Assistant legal consultant, and he was the legal consultant.
Correct. But he does not receive.
Not CCR.
CCR, she is not writing. No, the overall, if you read the text messages,
yes,
with the where is the element of sexual harassment?
This all messages are right outside, and messages which is from her. This is really called something. So that continuing messages were stopped. After that 3 to 4 months, she asked or she
what?
This is we're asking all these things for that. From that section, they were petitioned. After that case filed, still see filed this case for see the job to their job at High Court of Orissa.
Report.
Judge was a research. She is working at Account General Office as a research. She was working with the journal. So, chat started, and all this chatted, all the WhatsApp chat is chatted to the girls side. See, he replied the same.
You are very innocent. Your client is very innocent.
No, sir. I'm justifying that. I'm justifying the
WhatsApp message. Do you have them?
Sir.
You. Can I look into?
Yes, I am also. I have got.
You have what?
Yes, sir. All is there. Sir.
Most of them in Odia language.
Sir. See, annexure 2 on 6 pages also, 57 page, 57. The D4 persona, thus, yeah, sexual case. So where see depends of the also there. All the chats will just is each pages.
Somebody who knows they are in Oriya. Oriya language. So I'll send to a judge who knows Oriya language and Oriya culture. The same word, it will have some cultural content also. So those words have to be understood in the light of the culture. These people.
My lords.
Since the WhatsApp messages, which are allegedly a part of complaint of the sexual harassment, or in Oriya language. First, registry to post this case before other bench having knowledge of the said subject, said language, after obtaining, securing orders at the hands of Honorable the Chief Justice. Immediately.
See, the complete the mentally and the environmentally of the complete is very in the place.
The land
should be affected to the and his family, the son, and his completely schools and all the last 2 years we is single license
involves admission. Apology is a confession only, not to the police, but the concerned victim.
He begged apology only.
Are you ready to say apology? Right, sir.
This case happened, and this chat happened 4 months back. After several months,
Chats happened.
after several months, they are filing the case. After several months, they are filing case from my company on chat. After that, after 2 days, she filed the case as a challenging.
That bench.
Yes.
Right, sir. But then best way, see, in life, sometimes you have to go down. If not, you need to decide to hold back your temptation to argue and spoil the case. Sometimes the best advocacy is to go for the bargain. There is plea bargaining. Whether it is there even under the BNYS, I do not know. So, recommendation of Justice V.S. Malimat committee report, the CRPC was amended, providing for plea bargaining.
Yes.
Do you know plea bargaining in criminal law? Do you practice in criminal law? No.
No, sir.
Plea bargaining means the court will tell you, see, so many allegations are made against you, but this allegation we will say, instead of going for trial, etc., you pay so much fine, well, then go home. That way. So ask your client and come back. Instead of exposing himself to too many problems, life will play very cruel with individuals. That's how life is. P.B. Shelley writes, I fall on the thorns of life, I bleed. Sometimes it happens. You have said, but you say, I have already orally given you the apology. Over.
Committee already, justice they already told to him without a single inquiry happened over there. From the
chamber hearing.
Yes, sir.
Can we have the matter in chamber hearing with the presence of the gentle lady also?
Yes. Yesterday I also suggested it will better. But both are, he is married and the girl is also unmarried. So their life is there. So your lordship may better, it would be better.
Some judge who knows Oriya. Some judge who knows Oriya.
If both of them will appear before your lordship, it will be real.
Is it?
Will not send anybody.
Okay. Rehearse that order. Heard for some time. Come on. Although learned AGA Mr. Lenka stuck to his guns, come on, in all fairness suggested to explore the possibility of amicable settlement by holding chamber proceedings. With this proposal, counsel for the petitioner is agreeable. First step. Yes. Which is the gentle lady?
No, notice has to.
Notice has to go. Issue emergent notice.
54
to OP number 4. OP number 4. Instead of let's write like this, OP number 4. Till then, you tell them, your secretary will not immediately take the decision, I know.
Yes.
You just find it to be little slow. And she will be in all other matters.
Yes, I will.
Item 34.
Lordship, they fixed the date
on 18?
18th.
18 because we know the
On 18.
notice pregnancy. And actually, the between 2020.
अरे नोटिस ने कहेंगे डेट को
in which will be reopened the one day after the opening. Okay. Thank you.
Thank my Lord.
Item 34. Item 34. Complaints in 2 weeks. No.
The leave of your lordship, it is covered matter that your lordship would remember. I would beg to submit dual allotment and false affidavit by the Bhubaneswar Development Authority, multiple allotment, and allotment through it to be ownership, by virtue of which my allotment stands cancelled. That is the same.
Some Mishra versus.
Yes, Sushma Mishra, that your lordship have been pleased to deliver the judgment. A copy of it is with me. But why it has come up in orders, please. But it has been reported also. Local law reporter, it has been reported. In the rare portion, the petitioner has inadvertently prayed for quashing of the impugned order by virtue of issuing a writ in the nature of mandamus. I have only prayed for an amendment of the prayer portion to correct it as a shashura. And all other amendments and statements to be as it is, to remain as it is. Flag B is IA number 15805 of 2025. There at page 5, I seek your lordship's indulgence for amendment of the prayer.
Amendment of the prayer in the petition.
Yes.
What amendment?
Yes. Amendment.
The judgment.
No, nothing. Not in the judgment. It is another case. The judgment is a similar judgment in that Sushma Mishra's case. You are your
opponent.
Yes, my lord. I am for the BDM, my lord. My lord, kindly, my lord, any other day can it be taken, my lord? The file has been misplaced. So any other, as your lordship pleases, can trace out the file. And
you don't have a file.
No, my lord, it has been
you request to get your file from your senior friend.
Yes, my lord. I will
record copies.
Yes, my lord. Any day, other day, I will take the.
If your lordship so pleases, it can be taken up on Friday. This Friday, yes, it's already similar.
Similar, but we'll have it Friday, but in January, Friday. In January also there are Fridays.
Naturally, man. So, any date your lordship board.
Second week of January 26.
And may I be permitted to correct, your lordship may pass that prayer portion in the...
An application is moved seeking amendment of the prayer alone. Certiorari is to be sought for, mandamus is sought for quashing of the impugned order. First one. Such an amendment would not cause any prejudice to anyone. First of all, on the contrary, it would advance the cause of justice. First, next one, in view of the above, application having been favored, leave to amend as sought for is accorded. Petitioner to amend the costate, comment the pleadings. Yes.
Item 36.
36, my lord. I am a elementary school teacher. Challenging the RSCP benefit, citing Saraswati Bhai and others. The same case is pending disposal of SLP diary number 8465 in the last date of hearing. And the same cases in Gajapati district, Odisha, like Govardhana Bhuya and others. WPC OAC number 3916 of 2016. Same is disposed undated 2011-2025 by this Honorable Court in court number 12, my lord. Hence, my case is also covered as Govardhan Bhuya and others, citing Saraswati Bhoi and State of Orissa and others case. Undated 2011-2025 in court number 12 of this Honorable Court, my lord. Disposed same may please be, the same is covered to my case, my lord.
Yes, Mr.
Being
Lenkawati.
elementary school teacher.
Take instruction.
You want to take instruction? Which date?
My lord.
The lordship.
My lord. My lord.
Yes.
My lord. The similar matter is flag C. The judgment, web copy of judgment of this Honorable Court undated 2011-2025, Govardhan Bhuya and others has been disposed. Please see, my lord, flag C of the affidavit, the web copy of Govardhan Bhuya and others. So question of further giving date unnecessary I may fit fields. Flag C may please be seen, my lord.
Sir, we will give you, when you give one date to the government, suppose if they do not come with preparation, then we will agree with you and pass appropriate orders. Next date. On this matter, in the, any specific date you want? Give date. 7 January, all right. Seven.
Yes, may
Yes, sir.
I'm a virtual mode Miller and some personal difficulties.
Opposite party is the Orissa University Agriculture and Technology. My friend has filed this interlocutory application for
recall of the order Miller. I'm on virtual mode Miller. I have personal difficulty. I could not appear in person Miller.
That is only his name has not been reflected. He has been misunderstood by university. For that reason, my friend has.
Why I reflected he having argued the.
No, Miller. May I submit, Miller? This interim application filed for recall of the order dated 16/10/2025. At that point of time, Miller, to be very fair, Miller, the counter was not filed in the writ petitions.
No ground.
No, Miller. No ground. That is no ground. What I am submitting, Miller, the petitioner relied upon the judgment of your lordships in the case of Utkala University matter. So my submission was, Miller, I have no objection if your lordship remit the matter back to the authority to take a fresh decision in the light of the judgment of the Utkala University. It's a copy-paste order, your lordship find. It is all as good as I have considered the matter that all those things have happened, Miller. Therefore, that is why I filed the petition for recall of the order dated 16/10/2025, Miller. The lordship may see the order, Miller.
Yes, I saw the order. But other day, you said to similar.
Copy was also advance copy was given to him.
No, that's true. I do not dispute, Miller. The subject matter of all these cases, Miller, they're similar. That is no doubt about that. But the order of your lordship is, Miller, the similar situated employees have been given the benefit, Miller. Therefore, I had no instruction whether the similar situated employees have been given benefit, Miller. In Utkala University, the Learned Counsel appearing for the Utkal University, he has submitted and pointed out the annexure where he has considered that yes, the similar situated employees have been given the benefit, Miller. So far the OUT, this university is concerned, Miller, I had no instruction whether the similar situated employees has been given the benefit or not. Therefore, I had submitted on that, Miller, on that date, that I have no objection if your lordship remit the matter back to the authority to take a fresh decision in the light of the Utkal University judgment. That was what my submission, Miller. So your lordship may record my submission and presence, and your lordship may decide all those things, Miller. That is why I filed the recall of the order. That's order shows that it's a copy-paste order, Miller. Because without a counter, I cannot concede that all those benefits have been granted to the similar situated employees.
So now I am asking you whether similarly circumstanced employees this benefit is given. Now tell me.
No, that instruction I have issued, Miller.
No, unless you.
Yeah, then your lordship may take this matter next week, Miller. I will take written instruction from the university.
Only then be maintained.
Yes, Miller.
From that, what is stated in the court order. What is stated in the order is not correct, because similarly circumstanced employees have not been given benefit. Therefore, recall the order. That can be a ground. Not that you are property, that is no ground at all.
No, but
why don't you keep quiet?
Yes, I understand, Miller. That I understand. But what is the order? Your lordship may see it is adjudged. I have considered the matter that the similar situated employees and all other things have been happened. But since though there was no instruction to me in written that the similar situated employees have been granted the benefit, all your lordship may see from the order, it's very clear, Miller. So
that's very clear.
Yes, your lordship may, in that event, your lordship may grant 1 week time. I will take instruction.
Caller, the week after next. At the request of learned senior panel counsel appearing for the university to make a statement as to whether the employees circumstances similar to the petitioner have been granted
Utkal University.
Of the university, of the Utkal, of the, this is which university?
No. It is not Utkal University. That is the matter, Miller. In the case of Utkal University, it's all right. But the OUT...
University, similar benefits. Come on, as has been done in the case of Utkal University.
Man.
Okay.
We're extremely sorry for the case of some.
No, it's all. When one Bhagavan Rajanish says, when one speaks, others should keep quiet, unless one is stoned to death. We are not certainly stoning you to death. Yes. After one completes his speech, the other should open his mouth. Otherwise, the collision of words is not communication. It is collision. Violence to everybody. Yes.
Obliged.
Okay.
Item 30 it has been adjourned. Item 39.
Last occasion I have given the copy over judgment.
Order by judgment.
Yes, my lord.
We have already received the borrowage comment. Only short time maybe.
2000.
Because 1,70,000 1,56,000 is the fraudulent money. By fraudulent means he has withdrawn from the treasury.
Who has withdrawn from the cell?
The junior, the petitioner.
Not my lord, it is done by the DDO. My lord, allegation is different, my lord. 2000 February, we are placed under suspension. And proceeding has been initiated.
Against whom?
Against all those who are involved.
Including your petition.
Yes,
your client also.
But that was not proceeded anything.
How long?
2022 till that. So that's why your lordship, I given that coordinate bench judgment and also
What coordinate bench said?
Referring that Ajay Chaudhary case, I have given that.
Raising of suspension.
Yes.
Under suspension?
Yes, that's why I have.
How long you can? How long you will keep him home and pay our money?
Yes.
On the other hand, revoke the suspension, extract the work from him. If he is unreliable, post him to some other place where he can watch the movement of the waves on the Puri beach. You can't keep 5 years. How can you maintain suspension for such a long period?
Suspended on 2020.
Yes, February 2020.
February
2020. 6 years.
January is coming now.
Yes.
No, he has not continue.
He has not paid for a revocation of suspension.
Yes, I have many.
That's
the prayer here.
Yes. No. He has prayed here, my lord, for quashing the.
Quashing and other things I will never do.
No, that.
Let proceedings.
Yes, I am ready to face the proceeding.
You rescind the suspension. Yes. Post him to a place whichever you want.
Yes, I am no.
Okay. And hold the inquiry.
Yes.
All right.
Yes.
Okay. The essential grievance of the petitioner is reflected in the prayer column. First up, petitioner seeks quashment of all disciplinary proceedings on the ground of enormous delay proved in the matter inquiry without justification. First up, learned counsel for the petitioner alternatively submits that regardless of what should happen to the inquiry proceedings, his client cannot be continued under suspension. Can be seated. Vessel under suspension eternally in the light of apex court decision in Ajay Chaudhary versus Science. Next paragraph. Learned DG appearing for the OPs vehemently opposes the petition, contending that the charges are very grave and multiple delinquents are involved in the matter, and therefore delay would inevitably happen, which the court should be. First, he also tells the court that delay per se is not a ground for quashment of the disciplinary proceedings. First off, he further opposes the other prayer of the petitioner for rescinding of the suspension on the ground that since all the emoluments are being drawn by the petitioner, he should not worry about the ongoing suspension at all. First, even otherwise, according to the learned AG, no case is made out for rescinding the suspension. Next, having heard the learned counsel for the party and having perused the petition papers, this court is inclined to grant a limited indulgence on the ground that the suspension of an employee cannot be continued eternally by the Ajay Chaudhary Sura. A decision has to be taken to rescind the same, after the expiry of 6 months. First, the authorities have to keep in mind that the suspended employee also is paid subsistence allowance for the initial period, and consequently, the full salary is paid from the public exchequer, with no work being extracted from him. First, that is not a happy thing to happen in a welfare state. First, next paragraph. There is force in the submission of that counsel for learned EGA appearing for the OPs that liberty should be reserved to his clients to post the petitioner anywhere in the state after receiving the suspension, so that the public money would not be put to the risk of pilferage. First, it hardly needs to be stated that our Constitution recognizes employers' prerogative to extract the work from the civil servants by posting them in any place of choice, subject to all just exceptions. First, next one. Learned EGA is also justified in contending that the inquiry of the kind which involves alleged misappropriation of more than ₹1 crore with the involvement of several delinquents, really is bound to brook. First, delay per se, apex court said several times, is no ground for quashment of the inquiry proceedings. First, no exceptional case is made out for departing from the beaten track of law. First, in the above circumstances, this petition is allowed in part. Petitioner's suspension shall be rescinded within a period of 3 weeks, and he will be posted anywhere the state, keeping in view all relevant factors. First, the subject inquiry shall be accomplished within an outer limit of 6 months and report compliance to the Registrar General of this court. First, all contentions in the inquiry are kept open.
Item 40.
Item 40, we have complied. That the amount has already been released. 1 month salary for the month of April was
but instead of instead of my lord, my lord, they are now insisting me to enter your application in PRAN, my lord, which is under challenge, my lord, under Annex 6. Because I was appointed in, my lord, in 2000, my lord. Sorry. Can you see? In 1996, I was appointed. Thereafter, my lord, I was due to the fraud committed by the erstwhile inspector of schools, my lord, Hon'Ble, I was terminated along with all teachers, my lord, private school teachers. Thereafter, after interference of the Honorable High Court under Annex 2 and 3, my lord, government guidelines, your lordship will see. Thereafter, I was allowed to rejoin in my service in 2011. I was rejoined since 2011. Now they are insisting me to submit your application in PRAN instead of opening up GPF account, my lord. Already my GPF account opened since 2000, my lord. Your lordship will see Annex 5, my lord, which is under challenge, my lord.
So was re-engaged. After the old pension rule came, old pension rule was closed. 115.
Yes.
1/1/2005 onwards.
Yes. But he was much before that.
No, he was terminated.
Termination is set aside. That goes back to date of termination itself.
That part I will make your counter file. And your lordship's order has been complied so far with release of salary.
Release of salary is
yes, sir.
it is agreed at the bar that pursuant to order of this court made on 20/8/2025,
ସେମାନଙ୍କୁ ପୁଣି 2011 ରିଜଏନ୍ କରାଗଲା। ଇଏ ତାକୁ ଯେତେବେଳେ ରିଜଏନ୍ କରାଇଲେ ପୁଣି ଆଉ ଥରେ କୋର୍ଟରେ
arrears of salary have been remitted to the petitioner. Okay. Other grievance remains.
We'll go back to the
Already credited to the bank account. Already credited to the bank account.
Yes, remitted to his bank account. Okay.
Not that means please.
January 3rd week.
Always.
Item 41.
Can I come back?
Yes, sir.
Application and yes, Mr. Vishnu.
There is one item 55. You also remember that MSME matter, where Mukherjee, actually senior advocate, that one of the was absent.
Yes, remember. There were 3-4 matters, and I remanded them back for consideration of fresh.
Formulated some points. Actually, they have given me copy to get ready of those points which he argued. Today, actually, number one, I am badly placed after lunch immediately the third matters.
I am also badly placed because of bacteria.
But otherwise, also, I couldn't get ready yesterday night.
Okay. We'll have it in the second week of January.
Second week of
January.
Stay is there in their favor.
There is stay.
Stay is there in there.
Call in the second week of January. Interim order shall continue.
Second week of January.
Yeah.
Item. I tried to contact him.
Yes, brother.
Item 51. I am for the opposite party. After all, I have some personal difficulty. You need them next week. 51. I am for the opposite party.
Who is your friend?
No, the original counsel already expired. But somebody mentioned the matter has come. The original counsel whose name reflected, he expired. Mr. Mahanti. But now it hasn't come in the heading mentioned. Somebody has mentioned, but name is not there. Only I pray any day after next week or
after vacation.
Yes, I have no 51 item.
My lord, item 41. Kindly give some date. My lord, I am in PC due to personal difficulty. I am not appear today.
41.
Item 41, my lord. Deeply apologize, I am not appear. Due to virtual mode, I am appear.
You are appear for us.
I'm there for 41. We have not filed counter. That should not give me shoulders.
In my lord, permission, item 45, my lord.
At the request of petitioner.
Item 45, my lord. Only I request for adjournment. It is transferred for the council. Any date you lordship next week, any date?
2009.
My lord. Any date you lordship next week,
Next week we have difficulty in the second week of January.
My lord.
Inform the other side.
My lord.
Yes, sir. Okay.
Yes, sir. To mention a matter, so on board, item number 55. Item number 55 on your lordship board.
Mishra had come.
This is a matter where we had completed our arguments, and your lordship had only called for that LCR, which I believe has reached your lordships, just to ascertain, because the submission, one of the principal submissions which was made while attacking the award of the MSME is that on the ground of nullity.
Correct.
Because it was submitted that it was heard by A, B, and C, and judgment was delivered by A, B, and Z. And to verify that, your lordship had called for the LCR.
Correct.
So that only remains to be ascertained. Instead of the, if I could pray your lordship to take it up any day next week. For this small purpose,
it's already signed.
It has already been adjourned to 2nd week of January.
2nd week of January, I have signed the papers also. I told him that he told me that he will speak to you.
He had called me, but I was on my legs in another court. So I called him back, but he was busy.
I decided in the new year.
Since your lordship has already signed the order, otherwise it would have been concluded.
Correct. Yes.
My lord, may I be permitted to mention item 48? I'm appearing for my lord, I need to file counter.
48 to what?
48.
48.
Yes, my lord. My lord, in the
matter.
My lord, my learned friend of the petitioner. My lord, in the similar matter, 5,000 cost has been imposed. And this is also the same matter, my lord. 22.
Cost is imposed. This order is made here.
My lord?
In this also order is made? No. Let us see. Let it come in the first week of January. Yes.
Grateful.
Yes. Item 42.
Item 42, your lordship, today received the counter.
Today you receive
lordship, your lordship.
Who here the counter?
Counter.
Last time, copy to shop.
Let me 1 week for legender.
That is to be taken up. Because next matter is to be taken up.
This is that
42 manner item. We are intervention. Question is manner. Let them take time and legender. We have no issue, joining issues. Now question is, let the appointment be subject to result of the because why should we be deprived of the appointment? If that is the fellow, we have nothing to say on that.
The lordship, the interpretation I filed objection, lordship. In the two interpretation file, same petitioner file time and again, lordship kindly be my objection. Just receive the copy, lordship. Kindly see the lordship. Same petition, 9 petitioner, 7 petitioner, and again file after 2 days, lordship. Kindly see the 2 I was there. One is kindly see. See, just 1 IA 207. Can I speak? First file that see the but I'll show the IA. Yes. Ballot 20. Kindly see the IA. Sir, it kindly
has become a culture now. Yes. I am bit adjustment.
Difficult.
Different ourselves.
Dismissal. Yes, my lord. IA number 2086-25. I have filed. This is a file through me. I found that some persons have appeared through Mr. Bose. I want to not test that petition. That may be withdrawn.
Duplication has happened.
Duplication has happened. I don't want to go quarrel over that. But I have filed another IA by the other persons. They are selected now with the document. Madam, I will argue this case. The objection. Learned friend is the petition.
Physical education teacher.
This is line where I am so in another IA. I am there for intervention.
My IA now remains to be confirmed.
No, my IA is also there.
Yes,
another IA.
We are selling in the same boat, but different selected candidates. There was a misunderstanding. My learned senior had filed for certain persons who filed with me. He is now not present, so that anomaly is no more available now for consideration. This IA filed by my learned senior, Mr. Das, is different for other persons and for the other person. Your lordship may allow the IO to be heard along with the writ petition. There is no issue.
Along with the main matter, we can hear the.
Yes. No problem.
Now question is, Manor, when if they take, now we are unable to enter.
You have kept Madam a little away.
No, Madam.
This is in the Sanskrit.
I don't have the audacity to.
This is, yes.
Madam is also the same. But madam is for a different subject and for a different subject. One for PET and madam is for sunscreen. This is
My lord, the Staff Selection Commission, as per requisition from the government, has submitted a merit list. According to merit list, we have verified the documents and placed the candidates of PETs of different districts of DEOs, my lord. That we cannot give appointment pursuant to the interim orders passed by your lordship.
How many can?
About 700-800.
800.
Yes.
700. Oh, all the.
My lord, once your lordship will decide the main matter, everything will follow.
No, which one is yes. In this case, you are not clear.
Sanskrit,
In the Sanskrit, there is no.
Lordship only seeing the advertisement. I'm on PET.
PET. We are on PET.
Selection is completed by now.
Yesterday it was segregated.
PET means physical
education.
We are not stopping the way of.
No, that is why it was segregated yesterday.
This is the reason you are not segregated.
Lordship in Hindi, your lordship already directed to preliminary examination. Your lordship dispose the matter.
That will be has.
Regarding preliminary examination, when there are 5 times of a candidate applied, still preliminary exam must be. That is already decided. No, man, never. I have applied this application.
Wait, sir.
Yes, yes.
Have patience, sir. They are the fencers. They did not avail the remedy before your lordship. When all the entire system, the process was going on. At the fact end, when the appointments have been issued to us, they have come up before your. It is my lord will decide whether their petition is to be entertained or not. It is my lord will finally decide. But now I only pray, let the process continue with appointment, subject to result of your lordship's decision. If I am ready to accept that, because I will not claim any equity that I am being appointed, that I have got an unfettered right that I will enter into the arena. That will be subject to result of your lordship.
My senior advocate jo stated that is false. Kindly see my page, my annexure. I have applied in our at the application. The authority denied on 1/3/2025. That after completion of process, we supply the information regarding how many candidates are applied. Kindly see page 119. If they have argued, just
I have got
how they know about the candidate?
To add to Mr. Bose, Mr. G.
My lord,
what is your suggestion?
My suggestion is appointment be made, which will be subject to final outcome of the writ application. So this line has to be mentioned in every appointment.
No equity will be there.
Yes, so that
in other matter, in connected matters, also same thing has to be done.
Can be done.
So that will be aggrieved.
Because my lord may kindly see.
Now, how you will be aggrieved?
Yes, subject. Yes, my lord, I am saying. My lord, the entire thing, whatever was placed before lordships on the backdrop, that all are not elected candidate, and they are awaiting appointment orders. My lord, I will demonstrate from the advertisement itself and the definition of select list available there.
Everything is wrong.
They are not. The very selection on which they are embanking upon is not a select list at all, nor a selection. Yes. It's a provisional shortlisting only where.
No.
I'll demonstrate your.
What is correct?
Your lordship kindly bear with you. My lord, as your lordship have, if I can recapitulate your.
See the select list. My lord, yes. Page 100. Page 100. You used to look at page 100.
Since I am for
page 42. He's in the sun. Page 120. Page 100.
My lord,
meter. First case.
In case of
that is why I'm saying
once your lordship have decided the principle in Hindu, how can they will be permitted to give recruitment? That principle is decided here.
I give reason. Yes. I'll address your, you have argued now and I'll address that.
My lord, if your lordship will see that Sanskrit, your lordship.
Sanskrit, no, PET teacher.
No, let the PET. This is. My lord,
lordships. PET is going to the councils of PET address.
Yes. There's a confusion.
Kindly see it should be decided. Your lordship observe that the same will also do in case of connected matters. That is why I'll say. Such a list is not available in case of Sanskrit. Such a thing is not available.
Only PET.
Yes.
We are concerned with PET.
We are concerned
So far as these petitioners are concerned, it they are in the provisional list of Katak. One Digambara Kumar, other ones are.
No, whatever is select list is there. You suggest that you will issue appointment orders to these people.
Yes.
And that will be subject to outcome of the writ. Yes, we know. Equity and any other thing. They will also not see impediment here.
No.
Yes. No impediment also.
No.
Whatever it will be lispendence case. Whatever happens, that will happen is your submission.
Yes.
Yeah. Who opposes this? What is your version?
I am for the staff. We have recommended
the selection.
Your lordship, we do agree with my lord's. Your lordship, kindly see annexure to page 73. Kindly see.
73.
When advertisement issued, subsequently on the
we will hear that matter.
They have issued. Four category for pilgrimation.
Heard both the sides. First up, the interdiction of recruitment process would cause a lot of difficulty to the community of teachers, and that would affect the public interest. First up, the select list having been prepared and published, the same can be operated by issuing the appointment orders subject to outcome of the petitions. Also, every appointment order to be issued in terms of the select list shall specifically state about the pendency of the petition, and that the said appointment shall be subject to outcome of the said petitions, in which, on the basis of this interim arrangement, no equity shall be pleaded by anybody, in any way whatsoever. First off, ordered accordingly.
Interim order modified to this. The interim order modified to matter.
Call this matter in the third week of January 2026. Next. Okay.
There was Sanskrit.
Item 43.
Yes. Now there are Sanskrits.
Yeah.
Now
in Sanskrit, whether final list is
final list. No. Just let me submit. In this matter, the interim order was there. The selection may continue, but no final decision shall be taken. So everything is certificate verification is over. Merit list has been only awaiting publication of the merit list. The selection is over. Merit list has been prepared, but they have not declared it. At this stage, because of the interim order, they have not published it. Otherwise, everything is ready.
My lord, I am for the petitioner instance.
Yes.
In one of the cases, my lord, my petition is.
No, we will hear these matters. Yes. Let them publish the select list, issue appointment orders.
My lord,
all that will be subject to commission. He will not be prejudiced.
Let me direct that, but before that, your lordship may direct the content. I'll just take your lordship.
Say that was on that.
My lord, they kindly see. My lord, if the advertisement condition, I will bring it to your lordship's notice. Thereafter, your lordship may kindly take the call. My lord, that is what my honest request to your lordship. Your lordship may kindly see the advertisement itself. My lord, may kindly see my petition That is WPC number 316750 of 2024.
Yes.
Madam.
What is that you were standing?
Your Lordships, I was standing defect in the locus because of which merit should not be.
Well,
so that is why I thought
in my case, my learned senior is not.
We'll address all.
Is not a party, nor she has intervened for anybody. So in my case, my lord, I am just placing for your lordship's perusal. Your lordship kindly see. And only thing I want to say is, your lordship kindly see to the advertisement itself.
No, why I should hear the matter on merits now?
My lord, this is not a select list at all. Because
that is your first contention. Yes, is not a select list.
Yes, your lordship kindly come to page 31. Page 31, your lordship.
Not been published, no? Because
so on the basis of the present.
This 31.
Yeah. What contention is it is not a select list?
It is not a select list.
Understood.
Because the advertisement is having 3 stages of examination. Preliminary is the first stage, and there the condition clearly imposed was where the total number of valid applications received is more than 5 times of the number of advertisements, then the commission is to conduct preliminary examination. Here, my lord, the total number of advertised vacancies are 706.
That and therefore this judgment is applicable.
Yes.
Next one.
Yes. Next, my lord, here what has happened, my lord, the second stage is preliminary examination. So in the written examination, they have allowed all the candidates who had applied to sit at the written examination. And my lord, because of the interim order granted by this honorable court, no select list has been prepared, and there is a provisional shortlisting made, which is in the ratio of 100:150. So whatever select list they are claiming, these interveners are claiming that we have already entered into the arena of selection. That is not the final selection. Reason being, it only speaks about 150 times of the total number of select lists. And my lord, besides that, the selection process, the written examination is also marked by several irregularities, because as in the other case, the same pattern, everything, advertising being the same, the condition of that pedagogy and evaluation was there. Here, my lord, after realizing the mistake they have committed in Hindi case, Hindi examination, written examination was conducted on 15th. Here the written examination was conducted one day thereafter, that is on 17th. After realizing that, the question set which was prepared, that beyond that, a separate loose sheet was given or supplied to all the candidates without having any signature, any authentication of any authorities of the examining body. And ultimately, what they have found after the publication of the provisional mark list, we found that there are certain questions which are fundamentally wrong, and there are multiple questions also, multiple answers questions also. They have given the scope for objection that was objected to, and as against 12 questions, the petitioner, some of the petitioners pointed out, commission accepted 4 of them as erroneous, but instead of deleting all the 6 marks, 6 questions altogether from the purview of selection and restricting the selection to the total marks minus that marks of those 6 questions, what the commission did, commission granted en bloc grace mark to all the candidates, whether they appeared or they have not appeared, resulting into serious prejudice to the certain candidates who had given correct answer as well and who had attempted but given wrong answer. But these candidates who never appeared that particular questions of 6 in number, they were also allowed marks, resulting into serious changes in the ultimate analysis of the so-called preliminary test which was conducted. That is the other aspect. The third is, my lord, the third stage of examination is on the basis of that written examination, this so-called shortlisted 150 times of the vacancies, candidates who will be called, there, my lord, they will be asked for certificate verification. So certificate verification for this, an advertisement should, nothing has come on.
Why that person is coming in the front? Is he liar? Go back. Go back. Sit there. Yes.
Here, my lord, your lords may kindly see, the advertisement itself clearly says that clause 8 of the advertisement says the merit list shall be prepared in order of merit, post-wise and category-wise, basing on the marks secured by the candidates in the written examination out of 150 marks and found suitable in the certificate verification. The select list will be published equal to the number of vacancies advertised. So there is no such select list as yet prepared on the basis of which any of the candidates, including the petitioner herein, can claim that I am a selected candidate. Here the difference in situation is, the petitioner who is making out a grievance before lordship to whom I am representing, my lord, she is also a person who has been provisionally selected in the written examination conducted. My lord, now, my lord, the next question, note appended in the advertisement itself says, inclusion of the name of candidate in merit / select list published by the OSSC Commission shall confer no right on the candidate for appointment unless the Director Secondary Education Odisha or the appointing authority are satisfied after such inquiry or re-verification of documents as may be considered on merits that a candidate is suitable and eligible in all respects for post. So my humble submission before lordships is, my lord, here, my lord, on the basis of which all these clamor is being made that we have all allowed to appear at the written test, and naturally there is a shortlisting made that endures some right in our favor on the basis of which we can embank upon. My lord, I will just bring it to lordship's notice one thing. My lord, all these candidates, 696 candidates who were allowed to sit at the examination, they had applied against an advertisement, thereby according to all these stages of examination and terms and conditions of the examination. Now, my lord, at this point of time, all these persons under fortuitous circumstances wants a fiat from your lordship saying that my lord may kindly grant them the opportunity to bypass their own undertaking, given that they will be subjected to the terms and conditions of the advertisement as well as the terms and conditions fixed by the Staff Selection Commission.
Any other point?
My lord, one more thing, my lord.
No, I'm not hearing you.
Only when subject to lordship permission, but only the development, the subsequent development. After your lordships allowed that in the judgment, my lord, I'm just bringing the facts. Originally, 4,976 or something of that sort candidates in Pindi, they were also allowed written examination. Their results were not published. But after your lordship directed for preliminary examination by virtue of that your lordship's judgment, all those candidates were asked to preliminary examination, and what the Staff Selection Commission found after publication of their result of the preliminary examination, only 2,501 candidates have now been selected for appearing at the written test. This is the difference between the situation if a preliminary examination is held and if a preliminary examination is not held and a written test is conducted.
Your Lordships, the writ petitions which Mr. Mahanti is representing have been filed on 6/11/2025. That is few days before.
Yeah.
Date, check the date. And your Lordships, in one of the writ petitions, that is 31675 of 2025, your Lordships, my date chart contains all the detail.
Yeah.
Well, I haven't prepared a date chart.
In fact, I'm actually placing it the other way. I should have been placing it for the first, but as Mr. Mahanti spoke, so I'm placing serial number 17, of course, has been
a piece of mind of sharing with you all. Several petitions have been filed before the first court where information is sought for why you are not making the appointment.
Yes.
We are threatening the government officers from one side. From here, Mr. G and Mohanty and Lenka, they say, You threaten us from that side, why you are not making appointment? From here, you stay the appointment process. How the government should function? Number one. Number two, it is not some factory worker appointing. They are appointing as teachers. There should be a higher standard. The examination should be strict. Everything is ideal. I fully agree with that. But how many schools are without the teachers? And how long that can go on? Therefore, I am not taking up the matter on merits. I am only, without prejudice to anybody's rights, I am taking these matters for final hearing in the 2nd or 3rd week of January. In the meanwhile, entire recruitment process should culminate into the result. And that will not be prejudicial to anybody.
Yes, nobody will claim it.
Nobody can claim any equity or the thing. Simply, if the petitions are allowed, they should go home by taking the nearest bus. That's all. Therefore, we will protect all contentions which you have urged are definitely worthy of consideration. More particularly, my own judgment. Yes, I fully understand which your friend was arguing. And I have therefore, what I am suggesting is, let recruitment process reach its culmination point without claiming any equity or the like.
Yes. My lord, can I? My lord, now your lordship, my lord, I can. That is what my understanding, my feeling is. Your lordship have delved into the matter deep, and your lordship have delivered the judgment.
Correct.
The moment your lordship will be appraised of the factual similarity,
I will set aside the empire.
No, I am not saying that.
That is 47,000 teachers were set aside.
That is your lordship's discretion. I am nobody, my lord. It is my duty to place the matter before your lordship. That is your lordship's discretion to take the call, what to do and what not to do. I am too small a pride to say something. But the only thing I say, if at all the facts are the identical facts, all the dates, I have given a comparative chart between the
You came to court on 6/11/2020.
Yes, madam. I am saying that. The other case which your lordship accepted, there the candidate came on July. And here also, June. Here also, the first petitioner has also come in June.
June. He did not tell, now he has amendment.
No, his prayer is also there. He
is not there. That's the reason he
I am not misunderstood, my lord. Your lordship kindly see prayer in his case.
I don't see.
Your lordship late to all these matters.
In read petition number 160.
Take the heard learned advocates appearing for the parties.
My comparative dates out of Sanskrit and Hindi.
A host of contentions are advanced by learned advocates appearing for the parties. Most of them may be worthy of consideration at the appropriate time. First off, this court notices pendency of PILs and other petitions wherein the recruitment process has been interdicted, wherein our anguish is expressed as to why the vacancies are not being filled up, more particularly in the sector of education. First off. In fact, a specific stand is taken by the government in some of the petitions to the effect that this court has been interdicting the recruitment process and therefore the hands of the government are tied. First one. Next paragraph. Ordinarily, the recruitment process, more particularly relating to the schools and educational institutions, should not be interdicted, subject to all just exceptions. First off. However, this court-wide order dated so and so had permitted the process to go on, but short of issuing the appointment orders. First off, it is a matter of judicial cognizance that in several institutions, the teacher-taught ratio is terribly impaired. First off, that would not augur well to the interest of community of the taught. First off, in the above circumstances, the recruitment process shall go on and culminate into the fructification by issuance of appointment orders to the selected candidates. First off, however,
select list is to be published. Final select list is to be published.
If necessary, by preparing and publishing the final select list in a normative way. First off. Next one. However, the conclusion of selection process and the recruitment process by issuance of appointment order shall be subject to the outcome of these petitions. First one, every appointment order shall boldly state the same to the appointee, who shall not plead any equity or the like whatsoever. First one, the matter shall be heard on merits in the third week of January 2026.
Can it be little earlier?
Little early, because second week of January.
Same day will be fixed.
Second day.
Same day,
The same order has been passed in that case also.
That is all.
In that also.
Yeah.
Issue appointment. We cannot alter. Because the chief was saying, you are angry that appointments are not. I know you stay the appointment and this is how the courts are.
One more thing.
No selected candidate or appointed candidate can claim equity.
That is
Your Lordship kindly. Or that is impleaded. They cannot get themselves impleaded here.
That is very difficult. I tell you. Because of diagnostic case. I cannot know because they are not here.
But now it will create third party right.
No, they're respondents on. You need not. But I do not know.
Yes.
Maybe we will have to go back. Really, I do not know. But if it happens, it happens. What to do?
One more thing. This order may be passed in WPC 16242 because interim order is in that case. 16242 of Vinas Mishra.
This order is in WPC
16242.
16242 of 2020. Okay, put all numbers and parts. With all their names. Yes.
Once they will be appointed, but within 6 days after your Lordship passed that, now your Lordship is passed that order. The development which I want to bring it to your Lordship. Immediately after your Lordship passed that order, Staff Selection Commission published that notification directing for holding the preliminary examination. Within 10 days of holding the examination on 16/11, on 1st of December they published. So I mean to say, Staff Selection Commission is quite prepared with this contingency and
guessing something.
Yes, I have brought that on.
This direction that has complied.
Yes, I don't say without Lordship's direction.
No.
So they can hold it within 10 days.
No. Earlier, large number of candidates were there.
Little linguistic change. Linguistic change orders will undergo to match this.
I may be pardoned, my lord.
You are paid for that. You are paid for arguing.
Your lordship have observed on two occasions at least. My voice texture is
No. You are one of the finest lawyers. I tell you, one of the finest lawyers who will not let down the interest of the clients. Yes. Hey. Item 44.
My lord, in this case, the petitioner is challenging the disengagement order. It is 5/2016.
Yes.
Here we have filed counter. On perusal of counter, it was found that the marks what he has secured is detected in a belated stage of after 6 years.
Means
after 6 years, it was detected that her mark, what she has secured in the
university
is little less. So I want to know that from the department, from the concerned DO, that what was his or her application. What was the percentage of marks she has written
in the
application? So that matter will be clear that where is the negligence lies, whether it is on our part or in my part.
This you will do in first week of January?
My lord.
Because 9 years are.
Yes, my lord.
Reluctantly adjourned to first week of January 2026 at the request of learned AGA Mr. G, who wants to confer with his official clients.
Item 40 has been adjourned. Item 46.
Yes, in this case, I have filed an interim application managed. This interim application is only to clarify the writ petition filed earlier, my lords. In this case, inadvertently, we have not solved the copy upon the university, who is the contesting opposite party matters and BMC matters. I bring my notes.
BMC, copy notes are on the benefit.
You copy.
I will.
But university is.
Let him go through?
Yes, ma'am.
Okay, we'll have it in the second week of January?
Yes, ma'am.
Second week of January. At the request. Okay.
And if they want to file counter.
That's what.
Are you taking instruction?
Yes.
Your Honor, Western Utkal University and BC, BD, they are the appropriate party.
Yes, ma'am.
Those who have entered appearance also, they have filed the respective.
Yes.
Item 47.
May I please lose? And for the petition. So for the petition is concerned.
Why so many gentle ladies behind you? Are you afraid or what? Yes.
No. The petitioner challenged the inaction of the opposite party number 1, specifically opposite party number 1. They have not permitted the present petitioner to purchase the sued property. Fact remains, sued property belongs to DT, Lord Judge, and they have framed a policy, uniform policy, by the Annexure 2. So also they have issued notice by the Annexure 1 to sell this property. The person who are in possession of the sued property, that is the Annexure 1. Notice was issued. As per the notice by the Annexure 1, I have applied for a registration of the sued property as because I am in possession over the sued property since 1968. And I have constructed my dwelling house and resides over the same. Also paid the rent to the government. Holding cash was paid to the municipality. In such circumstances, earlier occasion, I have also filed a writ application. My lord has directed to the opposite parties to consider their application, but without considering my second application, they have again rejected the same with an observation.
Which section gives you right to buy? Like government has power to buy the property, compulsory purchase, acquisition. But where is such a provision?
Okay, Annexure 1, my lord. Just a glance, Annexure 1.
Annexure 1?
Running page 9, my lord.
Annexure 1 is what?
Running page notification issued by the
Jagannath Temple Administration.
It is hereby noticed.
The public for sale of the land mentioned below in respect of Khata number, Khatas and Mauza near Puri town of Sri Jagannath Mahaprabhu, Vijay Puri. That property also includes
No, where is the duty to sell to you? Where is your right to buy? Right to buy in someone's jurisprudence. Offense PGM is mentioned. Right, jural correlative is duty. Okay? If you say you have a right, its jural correlative duty should be with the temple. Where is that duty?
There is they have framed a policy by the Annexure 2, my lord.
Annexure 2?
My lord. Inform policy, my lord.
But it's in your language, not in court's language.
My lord, in Odia language.
What it says?
Clause running page 15, clause number 4A.
4A. Read.
The inform policy, Annexure 2, running page 15, clause 4, that very specifically clarified, more than 30 years, the person with possession more than 30 years, it will be alienated to him after taking maximum price from the suit property. Clause 4, it was written in the Odia as co.
This is relatable to which act?
My lord.
This is only in the nature and offer. Balfour versus Balfour. This is in the nature of an offer.
My lord.
Unless there is a legal compulsion to accept the offer.
Yes.
Where is that?
I am ready and willing to pay this.
You are willing to pay, but I don't want to sell my property.
They are
you sell your property, I am willing to buy.
My lord, they are interested to alienate the property.
That is no answer. Who appears for the temple?
OP1, notice has not been issued to us.
No notice is issued to you.
Yes, they have received the copy of the duty.
Your name is not shown.
No, your lordship.
How you come here?
Past order dated 24/4. My learned senior's name, there has been a typo. My learned senior's name is Anand Chandra Swai. Instead of that, Anil Kumar Swai has been done.
Registry to print the name of learned counsel Shri. You say that.
Chandra Swai.
Anand Chandra Swai. Right. No, even otherwise, what I say is irrelevant. No case is made up. There is a famous judgment of the apex court. No person can be compelled to sell the property, whatever be the price.
It was decided by the
long ago. 60s judgment. No institution of property is to exclude others. Merely because you are saying that I will pay 1 million rupees for a pound of bread. I cannot sell my cake, my bread to you.
Well, that's why
I'm asking you, what is the policy, statutory element of this policy?
Yes, ma'am. That is,
there is nothing.
That was framed in the informed policeman.
Under which law? A deity is an eternal minor.
Yes, ma'am.
Unless law provides for selling the property, they cannot do all that. Managerial people cannot do. Jagannath Temple, Lord Jagannath, though he is Mahaprabhu to all of us, he is a minor in eternity.
That policy was framed by the government.
Government. Where is the power to the government?
That is Annexure 2, my lord. That is.
Which is that power? Government cannot act as it wants, so it's not East India Company. It has to act under a statute. Which statute? Government cannot touch a property of the deities. Latest judgment you have seen.
On the authorities are the members of that person.
Yes. Under which law this policy is involved? And how can you compel the deity to sell its property?
We are not compelled, madam.
No, you're asking for an order.
They have issued the notice.
But now they are willing to sell.
If they will issue now, no, we do not want to sell the property, then we have nothing to say.
That's what.
Yes, ma'am.
They have rejected your application.
No, but they have not rejected on the same ground.
Whatever ground. Suppose moon is very hot and therefore I don't want to sell the property. Whether the validity of that ground be examined by us. No, moon is not hot. It is always cool. Cannot be. That is ownership. Ownership, Salmon discusses in his 12th edition, Fitzgerald's edition, is a bundle of rights. It includes property, right to possess the property, right to alienate the property, right not to do anything with my property. These are my rights. Unless these rights are regulated by a statute, you have no cause of action.
Let them submit the counter.
Nothing. Let it come. Petitioner is before this court, essentially seeking direction to the Lord Jagannath temple to sell a particular piece of property in terms of the arguable policy statement, copies whereof are part of the pleadings. First of all, learned counsel for the petitioner vehemently argues that in view of policy statement framed by the government and its high functionaries, a legitimate expectation was created, and therefore his client, being in the possession of the property since decades, had applied for buying the said property. The rejection of his application is absolutely unsustainable. First one. Next paragraph. Do you want to say anything?
No, Your Lordship.
You don't want to say anything. Next paragraph. Having heard learned counsel for the petitioner and having perused the petition papers, this court declines indulgence in the matter for the following reasons. First, number one. Salmon's jurisprudence in 12th edition by Fitzgerald states that ownership is a bundle of rights, which inter alia will include right to alienate the property, and right to alienate includes right not to alienate the property, subject to regulatory statutes. First off, such a statute is not cited before the court to relate the so-called state policy to the same under which the petitioner had staked his claim for buying the property in question. Next point. It has long been settled since the days of Privy Council that a deity is eternal minor, and therefore a minor's property cannot be sold in the absence of statutory enablement. First, as already mentioned above, no such enablement has been brought to the notice of this court. First, merely because some government or temple authorities had offered to sell, as has been argued before court, it cannot be compelled to accept the offer made by the petitioner. What? Restructure the sentence. Merely because the temple authorities or the government authorities had issued an invitation to offer, comma. Once offer is made by a citizen, it need not be accepted by the inviter. First off, it is a case like a bumper hull pen. Just look out that. Can you find out any bumper hull pen case from Google, which my professor used to teach us? Do you sell bumper hull pen for 30 pounds? Do you sell bumper hull pen? That was listener. And the owner quoted 30 pounds. That was considered whether that amounts to acceptance of the offer. And the House of Lords said it does not amount to acceptance. You are right. Give that judgment. I don't remember the name. The memory is playing trick with me. Yes. In the above circumstances, petition being devoid of merit is liable to be rejected, and accordingly it is. Take out that judgment. Right. Thank you, madam, for giving that judgment. Yes.
My seniors present.
Where your senior has not come nor argued, nothing like that. Yes, next.
Item 48 has been adjourned. Item 49.
Petition back to prefer this application for a direction to the opposite party number 4 to consider his candidature as a Shiksha Swag my lord, internally on the ground that he possessed the requisite qualification, that is, he has passed the city as well as the OTT, my lord. The petitioner
got to registry to send a copy of this order to temple authorities.
Petition.
Yes, sir. What is this matter, sir?
Matter regarding, my lord, the appointment of Shiksha Swag, my lord. The present petitioner, my lord, is possessed the requisite qualification and he has passed the city as well as the OTT examination, my lord. So he brought this matter to the notice of the opposite party, and I also filed a representation. My representation is by the Annexure 3 is pending before the opposite party number 4, my lord.
Consider that representation.
My lord, what the record speaks, he has given earlier a representation.
Post of that was rejected.
That was disposed of.
To consider.
My lord.
And now again consider will not help.
It was rejected. Let him counter copy paige.
Any counter is filed?
Yes, we have filed counter.
Yes. What is the
let him go through the counter and ready.
Yes, the so far the counter is concerned, my lord. In para 7 of the counter, my friend has stated he has not possessed the OTT qualification, my lord. So far the Annexure 1 is concerned, page 16, I have possessed the OTT, my lord. So I pray before my lord, let the opposite party number 4 concern, I will produce the certificate, academic certificate.
Let him, yes.
Short grievance of the petitioner is as to denial of appointment as a Shiksha Sahib.
My lord.
Shiksha Sahib on the ground that he does not possess OTET qualification. First of all, learned counsel for the petitioner submits that
for the year 2010-11.
For the year 2010-11, learned counsel for the petitioner vehemently argues that his client has already given a representation, specific representation dated 17 to 2021. Specifically stating that he possesses OTET certificate and therefore impugned action of the OPC is unsustainable. First stop. Next paragraph. Learned AGA Mr. G, after drawing attention of the court to the contentions in the counter, opposes the petition, contending that the claim of the petitioner as to possessing OTET is not true. First, having so said, he submits that he would instruct OP number 4 or 3,
4, my lord.
OP number 4 to look into the grievance of the petitioner afresh, and in the event he does possess all requisite qualification, his case would be considered for appointment favorably. First off, with this proposal, counsel for the petitioner is agreeable. Next one, in the above circumstances, 8 weeks. This one. Yes.
Item 50. Secondary litigation challenging the rejection order dated 17/12/22 for releasing of a training period salary or as in service candidate. Government has not filed counter.
Government has not filed counter.
Yes, ma'am.
No, we have not filed counter. Sometime maybe.
In the third week of January, at the request of the DGF to file a counter if any. Yeah.
Item 51 has been adjourned. Item 52. Item 52.
Yes. Yeah.
This case, my lord, the order of the State Education Tribunal is under challenge, wherein the claim of the opposite part number 4 was allowed. The big fact of the case is that this Prasanna Kumar Das, for whom I am standing here, petitioner, he was the first appointee. He was appointed in 1993. 1/11/1993 was appointed in elected physics.
Why two petitions?
Yes, one by the challenge the same order, one by the governing body, another by me. The brief fact, without opening brief, and just not said. I was appointed in 1993, the first appointee, 1/11/1993. Due to as a lecturer in physics, having the 73% mark in PG, because though the requirement is 55%, everything was all right. I was appointed, I was continuing. For some domestic problem, a case filed by my wife, that I have taken some leave, and ultimately the case was compromised, and I get back. My wife is there with me.
Yes.
But there was a criminal case. I got an acquittal also because of compromising all these things. For that period, I was absent with the college.
How long it was?
It was for 2 years exactly.
2 years?
Yes, madam. That was difficult because there was some family problem for which this man.
What should happen to the students?
Yes, what they have done, yes. That I am saying. That is the case. And governing body appointed the open number 4 in the intervening period, in the leave vacancy, to cater the need. I was never terminated. So when I came back, I have joined back in the duty. The governing body allowed me to join. And because the person who was continuing in that leave vacancy, and his was also not regular in that post. In the leave vacancy, I have found from the record there are 2 types of appointment order in his favor. Be that as it may, my lords, he was there. When I came back, and his service was automatically terminated because I am the only incumbent or original incumbent to that post, and there is only one post available in the yardstick. So he filed an appeal to the Education Tribunal saying that my service has been illegally terminated.
Was he appointed?
That was the leave vacancy. That's the admitted fact.
Where is that appointment order?
Initially, I was appointed on contractual basis. An advertisement was floated for walking into participating in the advertisement, and after I was issued the appointment order. Thereafter, I will continue.
Where is your appointment order? You mean to say for 2 years they should wait? It's an abandonment of the appointment.
My appointment, yes. He want to say.
No, your case. My lord, your case is one of abandonment of service.
Abandonment, as per the Odisha Service Code, my lord, 78 says, if a person is absent for 5 years continuously, then only it amounts abandonment of service. But for that, there is a rider that if the management has to proceed against the person as per the rules of termination. So there is no such procedure. That is the rule, my lord, with regard to amendment under the Odisha Service Code. That is applicable to this institution. So what happened, my lord, in the meantime, she has gone to the appeal. Just I'm completing this. I will go by all the documents, my lord. He filed an appeal to the tribunal. The tribunal, without giving a notice to me or the anybody, decided the matter ex parte. Against that order, I came before this honorable court. I filed an MJC for restoration of that, setting aside that ex parte order that was dismissed. So again, I came to this Hon'Ble Court. This Hon'Ble Court allowed the writ petition remitting the back to the order, but that person agreed by that order of the Honorable Single Judge. While a writ appeal, ultimately writ appeal also upheld that order. Matter went back to the tribunal. And the tribunal called for the records of the management with regard to this, how these appointments, what my lord, this fall from my lord's mind, the same thing was argued before this tribunal. And he came to a conclusion. The second person who was appointed, my learned friend's client, because he was appointed, he was not given an opportunity of being heard. While he was terminated from service, he is to be reinstated. So I am to go. That is the issue. I will show the records. If other parties are ready, then I will show the.
No, you have argued your case.
This is the thing more. Yes. This is the necessary essence.
One more plan. The prisoner was not absent for 2 years. He was absent from 9th of July 2001.
Okay.
To 4th July 2007.
This is not correct.
So it was more than 5 years. That rule will apply.
What will happen?
Mr. Das, just not. I'm sorry to say, sometimes you mislead me.
No, this is not the effect, man.
Don't do it. That will help. That will spoil your name. You are a promising advocate.
No, sorry.
Suppose if I share this view with my brothers when I eat my lunch with them, where do you stand?
Then I stand corrected because that
don't do it.
There is some.
Yes.
I have not gone through that part. Very kindly bear with me, madam.
No, not only.
I'm sorry, madam. I'm sorry.
I'm making this observation after observing 5 times, not the first time. I will not deliberate more because many people will be looking at you. If you want deliberation, I will do it right now.
I'm sorry, madam.
Yes.
I will stand corrected.
Don't do it. Yes.
Second clarification. In the counter affidavit at page 42, madam, the learned education tribunal, while issuing notice of the matter, passed an interim order, page 42 of the counter affidavit. Counter affidavit number 4. Counter affidavit number 4.
Well, take me through the order of the tribunal.
Page 42, minor. Order dated 7/6/2007. That's the first day of listing. Yes, ma'am.
Page number?
My lord, so page 117 of the brief. Findings of the tribunal.
That is the order. May I place that? The decision was stayed right on behalf of the applicant. Taken up.
117.
117, ma'am. PC 19592. The internal page 24 of the impugned judgment. The findings is that he was unauthorized absent for 6 years.
6 years. Which is that law which says if one is absent for 5 years, shall be deemed the employment.
72 for service code. But that should be followed by the procedure should be followed. Proceeding has to be started and concluded.
I have not submitted the most interesting fact by what they have done. The tribunal had such an interim order. The post shall not be filled up without leave of the criminal. In that case, initially, the
service code.
At that period of time, the petitioner was not in the picture. With the passing of the interim order, what the governing body has done, the governing body has reinstated. The governing body has given appointment to the petitioner. When I came to know that, thereafter I filed an IF, including the petitioner as a party to the appeal proceedings. Thereafter, the matter was initially it was passed ex parte. Thereafter, as per my submission from the senior, it was filed before this Hon'Ble Court, and this Hon'Ble Court demanded the matter for he had appeal of this matter. Thereafter, the tribunal, after reviewing all the submissions, has passed the order that the my termination is bad in that cannot be held to be legal. And the most interesting part is that
by terminating my services, my lord, what the governing body has done has stated the period of 6 years as an extraordinary leave on medical grounds and forwarded a communication to the government to pay the arrears salary for that period also.
Yes.
Anything from the governing body and the petitioner also going on.
But is
he was no doubt the petitioner in the other case was absent for 6 years. Well, 5 years, some more months. But the managing committee, governing body did not take any action against him. Rather, the managing committee, my lord, may kindly turn to my writ application 19968.
You are the managing committee.
Governing body, yes.
Governing body.
Yes, madam.
Managing committee, governing body, one and the same?
Same.
For school, managing committee.
School it is managing committee, for college it is governing body.
Okay.
And on 28, page 32, annexure 1, the governing body took note of the absence of the petitioner in that case and resolved that steps may be taken to engage a personal lecturer in physics on monthly.
But you appointed him on walk-in interview.
Initially, it was
no, my lord. That walk-in interview was a letter. Walk-in interview was advertisement was issued by the principal without any resolution of the governing body. In that walk-in interview, she was the sole candidate. You are the sole candidate. So the external who has come for the interview, he might have said since he is the sole candidate, there is no need of any selection. Thereafter, he remained only perhaps from 17/11/2006. Just
yes, heard. Both the petitions are dismissed, agreeing with the reasoning of the tribunal. More particularly when the idea of abandonment of service fructifies because of the Rule 72(2) of this service code, which reads as that. Next paragraph. Even otherwise, the tribunal's reasoning cannot be gone into the deeper examination since tribunal has accumulated wisdom, having been constituted under the provisions of Orissa Education Act 1969. First, a person who was away from service between during the period between 9/7/2001 and 1/7/2007 cannot be heard to say that he ought to have been subjected to disciplinary inquiry, and only thereafter the vinculum of service ought to have been put an end to. First off, it is a textbook case of abandonment of service. Yes, take this.
Item 53.
Okay.
Item 53.
Item 53, my lords.
Yes.
The learned counsel appearing perhaps is no more there.
Learned counsel appearing for the petitioner is stated to have passed away. First up, issue court notice.
My lords, the name is same. I am not sure whether he is that person or not.
Let it go. Let court notice.
No.
Issue court notice. Court notice. And we can say, learned counsel appearing for the petitioner is not heard of by those who ought to have individual force. First, issue court notice. Okay. Next.
Item 54.
Please.
Yes.
My lord, petitioner is a retired employee.
My lords, 54, I do not have copy of the brief. In fact, No, my lord, I do not know whether I am answering party or not. My friend is.
May it please this honorable court. I am appearing for the Revenue University. My lords.
University.
My lords, in fact, this the order under challenge is the order of the education department, and they have to defend the order. Revenue is more or less a pro forma party in this.
To defend, government should defend.
Government. The impugned order is at Annexure 14, page 50. It's passed by the Department of Higher Education pursuant to a direction of the Honorable Court asking them to dispose of the representation.
I have no objection, my lord.
Yes.
My lord, he is a retired employee. He's getting low pension.
If you give him, he will argue.
It was issued since long, my lord.
All right, give our copy.
No, I have given.
Call in the second week of send out the matters.
Second week, no problem.